a very urgent unlisted motion, my lord. Yesterday I received the message for doing the election duty. Because of my serious illness.
Give.
So may I be next to Punjab election matter, your lordship. During scrutiny, my nomination was accepted by the in the final list of contesting candidates.
Give.
But mine also same, my lord.
Same matter, your lordship. Seek leave to file.
My lord, similar prayer, my lord. Scrutiny name was a form be accepted. Thereafter, name vanished from the list, my lord. The contesting
They
Similar
are
matter, my
asking
lord.
denied to file nomination paper.
সুব্রত কোথায়? প্রদীপ আসেনি, প্রদীপ আসবে না? আপনাকে পাঠিয়েছে? লিভ দিতে হবে এগুলোতে। And please serve all copies upon Miss Sinha. Gratefully, lordship.
My lord.
Give.
My lord.
Hey, Ranina. Hey, Ranina.
One by one.
For this matter, they too have been denied to file nomination paper. So I have filed the nomination paper. So hauling it, and sir, I have been consistent. I have given the cost of. But
And you are coming so late. Whatever, I do not know what will be the consequences since you have filed.
My lord, similar matter during scrutiny, my name was there.
Give.
I am also paying. My lord,
Come at 1 o'clock.
I am also paying for.
1 o'clock. Serve notice 1 o'clock. সবগুলোকেই একসাথে রাখা হোক। 1 o'clock. Give. Yes, all matters 1 o'clock
My lord.
today.
My lord, I am seeking leave, my lord, to move, my lord, urgently, unlisted. My lord,
When?
my demolition, my lord, my demolition is scheduled on Wednesday morning at 11 a.m. Day before
Wednesday.
yesterday, I've learned.
On Wednesday morning.
My lord, kindly take it up on Tuesday if possible, my lord.
Why?
My lord, I'm really, my lord, something was,
48 hours notice is to be given.
my lord, I've sought
Today
leave
you-
for short service as well. Kindly, my lord.
Assuming. Which area? KMC?
KMC, my lord, borrow 9,
Wednesday.
Wednesday morning.
Yes, Wednesday
I'm
morning.
so grateful, my lord.
Serve notice.
Yes, my lord, we'll intimate.
Fine leave I am mentioning. I have filed an application. Now, my lord, your lordship.
Microphone is there. Please use it.
My lord, could you kindly take it up on Tuesday, my lord? Wednesday, my lord, I won't be in Calcutta, my lord. Please, my lord. It's a humble request, my lord.
I
Kindly, my
don't
lord.
think it will be possible because there are so much of other urgent matters.
I'm
My lord,
grateful.
I filed the application. My lord, your lordship knows the person who is the contractor, either in Gram Panchayat, Jela
What do you
Parishad.
want? Huh?
Now, my lord, kindly let it take it, let the matter be taken up, my lord, on Monday. My lord, I have filed, my lord.
You have filed.
Yes, and serve notice, my lord, upon all.
Very well. Urgent motion on Monday.
But in respect of item number, my lord, one.
1 minute. 1 minute. My regular officer is not here. Please wait. Monday urgent motion.
My lord, may I be allowed to mention?
1 minute.
My lord, in respect of item 1158, my lord, I am the respondent, my lord. My work is continuing, my lord, but due to pendence of the case, my lord, petitioner is dragging the case and police authorities.
Petitioner is dragging the case.
Petitioner, my lord, only to stop, my lord, police, my lord, informing me to stop my work, my lord. So that my materials is damaging, my lord, just to kindly fix any date
Why?
as your lordship
There
becomes.
is no order from the court.
No, my lord, nothing.
Then?
But so this only pendence of the case, police is doing that. During the matter is pending, so you have to kindly fix any date as your lordship convenience.
No. It cannot
Otherwise,
be
my
fixed.
materials
It cannot be
damaged.
fixed.
But any day, my lord, you have to kindly.
Extension of interim order, my lord, interim order expiring by the end of this month.
End of this month, 23rd. Very well. Next week it will appear.
My
Give
My lord, mine also, my lord.
extension of interim order.
My lord, your lordship had passed interim order directing, my lord, for the Jhalda municipality chairman, my lord. There was an interim order for the appointment chairman, my lord. But the order is expiring on 30th June, my lord. Let this matter appear, my lord. Extension of interim order.
Yes, extension.
But there were two matters that were tagged together.
When your lordship was not here, my lord, when your lordship was not here, my lord, Jasi Bhattacharya was pleased to grant an interim order in one of the matter, demolition matter. Now, my lord, matter was supposed to.
You want extension?
Interim order will expire on my lord Tuesday.
Give Monday it will appear or Tuesday it will appear, whenever it will appear.
May I have your lordship's?
No, sorry, please. It cannot be done with so much of matters. It is not possible. There is no order. It cannot be done. Please wait.
May I have your lordship's kind leave for mentioning a matter for categorization, my lord?
Categorization.
This is the case of unauthorized construction, my lord. It has been categorized under motion municipal matters. We have already served notice on the other party.
Well, what is the difficulty if it appears under the heading municipal motions?
My lord, this is under unauthorized, it's a case of unauthorized construction, but it
Maybe
has wrongly
there are-
been,
It is not wrong. Motion is the entire bundle and over there anything can come. All matters.
my lord,
So
we
it
have
cannot be.
served notice on the other party for this mentioning specifically.
Very well. So you have served and you have mentioned and your mentioning has been refused. It is as easy as this.
Lordship,
I am mentioning contempt application for inclusion.
No, madam, no inclusion now. Call the list, please.
Your Lordship, one leave to mention, Your Lordship, Panchayat matter, nomination cancelled, Your Lordship. Deeply obliged, Your Lordship.
I'm applying for the folder.
Item 1.
Date by Mr. Shubhranshu Panda. And I'm paying for extension of time to file affidavit, my lord. on
Why?
behalf of the claim.
Now each and every matter cost will be imposed.
Give me one week time, my lord. In the meantime, we will file, my lord.
Vacation bench order.
In the meantime, we will.
Do you understand what is the meaning of extension of interim order in this matter? You have raised a demand of 30 lakh of rupees.
My lord.
The moment you extend it, the petitioner is not required to pay. Unauthorized construction remains. Why will this be permitted?
Oh, my lord, they have, my lord, made an unauthorized construction. Thereafter, my lord, the proceeding has been initiated, and my lord, the condition that you have to pay 50% of the, my lord, the charges, then, my lord, the proceeding to be initiated. They challenge this, my lord, that quotation. My lord, the honorable,
So what it means? You have raised a demand.
my lord.
Because of the interim order, he is not being able to pay. Will you not move ahead with this matter, or will you keep this matter pending
no.
so that he is not?
My lord, only, my lord, I'll be praying for, my lord, only, my lord, the 1 week time, so I can, my lord, file a affidavit.
So from 29th of May, you
My
could
lord,
not find time.
Yes, my lord, this is, my lord, fault.
The affidavit in opposition directed to be filed by order dated 29th May 2023 has not been filed till date. Stop. Prayer has been made for extension of time for filing the opposition. Stop. On such prayer, peremptory extension is granted till 7th July 2023 for filing the affidavit in opposition. Reply, if any, be filed by 14th July. List on 26th of July.
My lord, 2 days
My lord,
back,
the
my lord, I have
interim order
already-
may be extended, my lord.
The interim order that is subsisting in the matter is extended till 30th of August 2023 or until further order, whichever is earlier.
Grateful.
Under the heading, let us see.
Well, I'm
Ashok?
sorry, my lord, I could not prepare because, my lord,
My
2
lord,
days back, my lord, I have received all instruction. My lord, I need some.
My lord, this will appear under the heading hearing, my lord.
Let us see the hearing where it can be included, or I can give you the liberty to mention.
My lord, that liberty to
Yes,
mention.
do one thing.
No, my lord,
Wait,
lordship
1
can-
minute, 1 minute.
lordship can fix that, my lord,
Wait,
because
My lord,
of-
kindly, my lord, liberty to mention, my lord, will serve
Liberty
notice
to
and
mention. Date টা returnable date দেওয়ার দরকার নেই. Liberty to mention. Before any other bench having determination to hear the matter.
No, he's-
grateful.
After 10 July, talks of settlement is going on. 15 July, talks of settlement is going on.
Learned advocate representing the petitioners and the private respondents submits upon instructions that talks of settlement are going on in between the parties. Stop. Accommodation has been sought for. Stop. Let the matter be delisted for the time being. Liberty to mention.
Grateful, lord.
I am hearing for the petitioners, my lord.
This is the affidavit. My lord, until 2015, the name of the petitioner owners were there as the owners. From 2016 June, my lord, the corporation has transposed as the owner. I am demoted as the occupier, my lord. That, my lord, will find at page. My lord, come to page 50, my lord. This is, my lord, there's a no due certificate as well, which I had obtained during which course, my lord, I have discovered that I've been transferred. My lord, 50 annexure P6, P7, my lord, that is my case, my lord.
Twenty 15,
This is 2015, my lord. This is here.
2016.
My lord,
And where is the next bill where you have been transposed?
my lord, the next bill is, my lord, at page 89, 55. 50, 52, 55, 50, 52, my lord. The annexure P7, my lord, will find. 52, 53.
What is the answer?
What I have, what?
Inventory list.
Exactly. Entry is has to be or with some basis. I just cannot take any property into my inventory. They told me that there is a that as it may
Between, lease between,
in favor of corporation.
My lord, I have.
assuming
Corporation lease people.
it's a corporation property, it was leased out.
Now, my lord, they have made a representation in lordship fine at page 87. That is probably the last representation given
Right.
by them.
Right.
June 22.
Yes.
Right.
Now, my lord,
And are everything mentioned over here in, is it a detailed representation?
My lord.
whatever is required to be decided, it is there. Or the respondent number 3, that is assessor collector law.
Let him decide.
Well, just your lordship pardons my impertinence, your lordship in the order records that whatever the basis, we should disclose, not only give details, but also disclose the evidence based on which this entry has been made.
Chief valuer and surveyor.
No, my lord, this assessor collector not
4.
we
Yes,
will
for a
take
number.
information from chief valuer chief valuer and surveyor. Sorry, my lord, assessor collector, it is 4. 4.
Assessor collector is
No.
4.
Yes.
Yes.
Let him decide, giving details
Please
of
come.
how it has been done.
So what is his office?
The matter relates to the premises number
My lord,
17/2, Kali Prasad Chakraborty Street.
কাকে রেখে? Manager কি কি করছে? Chief valuer, chief assistant. এরা করে আমাকে দিয়েছে।
Bearing SSC number 11-007
যাই হোক,
-17 -0038 -0.
দাঁড়া এক মিনিট দাঁড়াও।
Stop. Paragraph. The Kolkata Municipal Corporation raised property tax bill in favor of the petitioners, mentioning them as the owners of the subject property. Stop. The same continued till 2015-16. For the year 2016-17, Kolkata Municipal Corporation raised property tax bill wherein it was mentioned that Kolkata Municipal Corporation is the owner and the petitioners herein were the occupiers of the subject property. Stop. Next. The petitioners submit that they were transposed from the status of the owner to the occupier, status of owner to occupier without granting any opportunity of hearing. Stop. No notice of the transposition of the status from owner to occupier was ever issued upon the erstwhile recorded owners.
Well, a
Stop.
non-encumbrance certificate is also on, I mean, no due certificate, my lord. No due certificate is,
Kolkata Municipal Corporation issued no dues certificate in favor of the owners of the subject property in in the month of February 2016, mentioning that there is no dues in respect of the said property till 31st of March 2016. Paragraph. The petitioners filed objection before the Kolkata Municipal Corporation, but the same is yet to be considered and disposed. Stop. Next. As it appears that admittedly no notice or opportunity of hearing was given to the petitioners prior to such transposition, accordingly, the respondent number 4, being the assessor collector within bracket north, is directed to consider the representation filed by the petitioners on 30th of June 2022. Now, representation of the petitioners dated 30th June 2022 received in the office of the respondent authorities on 4th of July 2022.
my lord.
In accordance with law, after giving reasonable opportunity of hearing to the recorded owners and any other necessary parties. Stop. The aforesaid respondent may consult the records maintained in the office of the corporation and obtain necessary information from the chief valuer and surveyor, KMC, and pass a reasoned order in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the parties immediately thereafter. Stop. The assessor collector within bracket north shall give details, including the evidences pursuant to which the erstwhile recorded owners were transposed to the status of occupiers of the subject property. The writ petition stands disposed of.
I'm grateful.
Learned advocate for the petitioner is directed to forward a copy of the representation dated 30th June 2022, along with all documents in support of their claim to the aforesaid respondent at the time of communicating the order of this court. Next, it is made clear that this court has not entered into the merits of the claim of the petitioners, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation. Stop.
I'm grateful.
Affidavit of service taken on record.
My lord, in respect of item number 4, my lord, I beg to appear on behalf of respondent number 5 and 6, my lord. I have seen the service, my lord. It shows that it has been affected too. But the difficulty is this: they have affected service in a premises where my client does not reside. So, my lord, it's a dilapidated building, my lord. Only thing I'm humbly submitting, my lord, 1 day's accommodation may be given. At my cost, I'll take a photocopy and come back before your lordship on Monday.
One minute, twist.
Oh,
Twist. So I am not paying any relief against the private respondent.
But I'm a
Whatever,
necessary
let
party
him
because
go see what is there.
I am the landlord and the developer, and they are the tenants.
Ready with instructions, or you need time to
I have a preliminary instruction.
take little bit more detailed instruction, come back.
More detail, if your lordship will please to require, if it is sufficient, then
It is up to you to take a call whether you will require any further instruction or not. In that case, let it be on Tuesday.
Tuesday, yes, Tuesday.
Learned advocate representing the private respondent submits upon instruction that his client is yet to receive a copy of the writ petition. Stop. Next. Prayer has been made for adjourning the matter for the day. Stop. On such prayer, list on 27th of June. Give a copy, or he can always collect a copy.
Get up.
My lord, it was my lord's desire, my lord, to know, my lord. If your lordship recalls, it is that matter, my lord, where the order of the hearing officer was challenged. Two orders of the hearing officers were challenged. This my lord had taken up yesterday. And I have, my lord, placed a division bench judgment, my lord, of Paresh Company, showing that these two orders, my lord, are nullities. It has been held by the division bench that orders of this nature, which do not contain any reason, are nullities. Now, these are orders which have taken place, my lord, from
12, 13, 13, 14, 15, 16.
Yes. Now, my lord, I have challenged, my lord, these orders. They are single-lined orders according to the judgments of this.
How much have you
court.
paid?
Yes, my lord wanted to know from 11, 12 onwards, my lord, I have been. My lord, from 11, 12 onwards, my lord, I have been paying. They have sent all the up to 18, up to my lord sees the orders have been made in 2017. The orders of the hearing officer, they have been made, my lord, in the year 2017.
Not here, often with you.
It is with me. They have been sent. They have been downloaded. My lord. My clerks are-
Your learned senior friend has a copy.
No, I can show you, lordship, my lord, the immediate payment.
How much is due? 2 crore.
Due,
That
my lord,
is-
they are due, my
I
lord,
have
it will
seen
go to
that.
20 crores. my lord. Tomorrow it will go to
Otherwise-
20 crores.
Wait. Otherwise, from 18, nothing, no payment.
Up to 18. My lord, my lord had inquired. 11, 12, 12, 13, 13, 14, 14, 15, 15, 16, 16, 17, 17, 18. I've been paying at the admitted rate of 3 lakhs. My lord has seen on the earlier occasion. 3 lakhs was then subsequently catapulted to 18 lakhs. Then it, my lord, went to 20 lakhs. Then it was brought down again to 18 lakhs.
Let him make some payment and you consider. But then what will be the, wait, I have heard.
No, kindly set it
you-
aside. Lord, only one prayer I'm making. Lord,
If
they are not
you-
going to budge. I'll tell you, lordship.
Wait,
Fine.
if the order passed, where is that order? Let me see.
Yes, yes.
ওই অর্ডারটা কালকে দেখালে দেখান তো।
Lordship gets it at page.
Unreasoned order. If it goes,
My lord, he has addressed on 2 points. That is non-receipt of the copy of the order. That was his first point, that I have not received the copy of the order. And it has, so my question of paying the.
Kindly see, my lord, the orders, my lord. Kindly
not
see
only
just
that,
once.
not only that, they are unreasoned, only one-liners.
One-liners, they are nullities.
I have
The
seen
entire, my lord, I will have to show you, lordship, that the entire demand is based on a nullity. Kindly give me a second. This
Page
is, my lord,
56, you've shown,
yes. What I wanted to show you, lordship, is that it is all based on these orders. This, my lord, kindly see.
What is based on? Subsequent valuations.
These are all based on those 3 valuations. In order to show
Subsequent
that-
valuations.
Subsequent
Obviously, it has to be.
Yes, there's a letter of intimation of 5th June, which they had annexed to, my lord, their notice. That letter of intimation, my lord, I have pleaded. It's part of my annexure P9, but it was inadvertently not annexed. Now, my lord, this is the letter of intimation. My lord, you can see this contains.
Very well, I get it, that it will be according to this 80 lakh.
So it's on 18, 20, and 18.
18.
All these 3. Now, these are payment due bills, PD.
Yes, one-line orders, I have heard you.
May I now address on one line?
Please take your seat.
Yes, my
But
lord. But I'll keep quiet.
Quote unquote, one liners, orders which are one line. Now, my lord, to appreciate that one-liner orders, I will be placing two sections of before your lordship. One is section 186. I borrow the term from Mr. Banerjee, one line. Malad, kindly take page one, section 186 first. Malad, page one is section 186. The duty of an SSC after getting the notice. Any objection to the annual value determined by the corporation under section 1 and 2 of section 180 or clause A, clause B or clause C of section 185 shall be made by the owner. Objection has to be made by the owner or the person liable to pay the property tax in writing to the municipal commissioner before the date fixed in the notice under subsection 4 of section 184 and shall state in what respect the annual value is disputed. That is the duty of the assessor. Not only to give an objection, he has to state that these are the, in this respect, I am objecting to the valuation and this valuation cannot sustain. Then, my lord, the duty of the hearing officer. What the hearing officer will do? (188). Well, hearing of the objection, if there is any. The objection filed under 186 shall be entered on the date, time, place, 2, specified under subsection 3 or subsection 4, and after giving the person filing the objection an opportunity of being heard, either in person or through the authorized agent, the officer appointed under 187 shall determine the objection. So, two things. One is, he has got a notice, there is no dispute. His authorized representative appeared before the hearing officer, no dispute. Now, before that, he had to file an objection, and the duty of the hearing officer was to consider that objection. Now, my lord, would kindly come to that judgment of company, what he is relying upon. So, one-page order, my lord. My lord, I am placing paragraph 3 and 4, what he has placed. The appeal is directed against an order dated 9th April 97, whereby and whereunder the learned trial judge allowed the writ petition filed by the writ petitioner respondent questioning the validity of an order passed by the hearing officer. Hereafter, my lord, on an objection filed by the writ petitioner and as regards the valuation of the premises. Then again at paragraph 4, the learned trial judge, in our opinion, has rightly held that the said order is a reasoned order, not a reasoned order. The hearing officer, while disposing of thereafter of the objection filed by an assessee in the statute, is statutory obliged to pass a reasoned order. So, unless there is an objection, I cannot invent reasons from the sky and incorporate in my order and decorate it as a reasoned order. So, first presupposition is there has to be an objection. Where is that objection? Where is that objection? I ask a question to myself. The second time he is coming. The first petition was filed in 2020. I have got the copy of the petition with me. There was no objection filed with the petition. Here also, your lordship kindly, your lordship doesn't have to take my submission on its face value. Your lordship sees the petition itself. My lord, in writ petition, not only the pleading has to be there, but the documents in support of that pleading has to be also there. Your lordship checks whether there is any objection. My lord, I asked my officers, there is none. The representative went, appeared in the hearing. He has seen my records based on which the valuation was proposed. He has seen those valuations. Thereafter, he did not object to it, and he has put his signature on the objection docket. Your lordship would kindly open the order, those one-liners. I again quote Mr. Banerjee. Those one-liners. Your lordship would kindly take those one-liners. It's at page 56.
Right side,
Yes, my lord.
right side.
Yes. And he receives the copy of the order on the same very date. No, this is incorrect. Did I say a single word when you are making your submission? You're making a factually incorrect. No, I'll show, my lord, that this is corroborated. He has received the copy of the order. Incorrect. Very well.
Please don't make running commentaries. He is
Madam,
making
On
submission.
the right hand
Right.
side, there is a signature. He has received the copy of the order. He filed the first petition, which was disposed of by your lordship. There was no complaint regarding non-receipt of the order. Now, my lord, would kindly come to page 30. Page 30. My lord, page 30. This is the copy of the appeal filed before the tribunal, even when the first petition was moved. But a person cannot go on approbating and reprobating. Well, it comes to page 31. Comes to paragraph 5. The copy of the hearing officer's order dated 19/7/2017, received by this appellant on 19/7/2017, which is filed herewith. And if he does not file the copy of the order with the copy of the appeal before the tribunal, well, fait accompli. He cannot develop, go on changing facts from proceeding to proceeding, from authority to authority, and say that I have not received the copy of the order. If this is, my lord, it's a very, very clear statement without any scope of any doubt. Now, your lordship turns the page. Ground C. For that, the impugned order is not a speaking order. So he knows that it is a, quoting Mr. Banerjee, one-liner. No reason. So the fact, what I am submitting, that he has received the copy of the order on the day itself is corroborated from his own pleadings before the tribunal. And this invention, I would say, that non-receipt of the copy of the order started from the appeal court. When the appeal was filed against your lordship's order, it is at that stage this non-receipt of the order came up. Why? My lord, I ask a question to myself, why? Why is, the answer has been given by Mr. Banerjee, that unless I receive a copy of the order, my supplementary bills are just dead, are just papers. They are not right. I cannot ask him to pay the supplementary bills in terms of the judgment of my lord Mr. Justice Bhaskar Bhattacharya long time back, that unless the copy of the order is served or given to the assessee concerned, my right to claim the supplementary bills do not arise. And that is the reason he took this plea that I have not received the copy of the order. This is a classic case of approbation and reprobation. Now, my lord, appeal was filed before the tribunal. No compulsory pre-deposit in terms of section 189(6) was made. It went on. Since it was not done, we have given him the letter of intimation. Your lordship said that since the appeal is pending, don't take any coercive measure, and said that the appeal tribunal will dispose of the appeal in accordance with the law. Accordance with the law means pre-deposit in 189(6) has to be made. Then only the tribunal can take up the appeal. It was not done. A belated appeal was filed. The Honorable Division Bench also did not interfere with your lordship's order, only said that he will make the pre-deposit and the tribunal will decide. Then thereafter, the review, wherein he came up with that I will withdraw. My lord, my instruction is till today it has not been withdrawn. And the paragraph 26 of the writ petition will make it clear. Your petitioners have taken steps, filed application in all the three appeals stating that since the orders included therein are totally unreasonable and nullities in law, the appeal challenging such nullities honest and thus being formally withdrawn, reserving the right to challenge the action. That is, till date, it has not been done. That is my instruction. Let my learned friend show that yes, it has been withdrawn. There has to be an order. So, this is only a ploy to dodge the public revenue, which is meant for public interest and public purpose. And it is going on since the time the hearing officer has passed that order. And today the dues are more than 2 crores. So he has received the copy of the order. There was no, prior to that, he has received the copy of the hearing. There was no objection on record. The order was received. Filed appeal, stating very clearly that I have received the copy of the order. Then he comes up in the appeal and says before the appellate court, Honorable Division Bench, that I have not received the copy of the order, which is not borne out from the records, his own statements. Now, my lord, another aspect of the matter. So the person cannot go on making same prayer. Same prayer. One of the earlier petition is for your lordship.
No.
This is the earlier petition. Your lordship would kindly consider prayer B. Prayer B, your lordship consider. He said, prayer B, in prayer B, he says, a writ of mandamus or like nature do issue commanding the respondent authorities to cause reassessment. Your lordship get it. There reassessment of the annual valuation of the said property with effect from 31st May 2030. This is a challenge to the valuation. If your lordship directs, then I have to again go through the entire rigmarole of giving him notice, determining. So your lordship, it did not hold good before your lordship did not. So it is to be construed that the court rejected this plea. Appeal is nothing but the continuation of the original proceeding. So this, with all these prayers, it was before the Honorable Division Bench, but the court again did not go into this aspect. Now your lordship sees the prayer in this writ petition. Its first prayer of the writ petition. Compare this. It is in effect the same. His first prayer is prayer B, page 17 of the writ. Order be made declaring that the orders of the hearing officer dated so being annexed P5 hereto are nullities in law and void of being. In effect, that prayer B and this prayer B is the same. So that prayer B was already rejected by the Honorable Court. Even it did not hold good before the Honorable Division Bench. And again, the same prayer is being made. To what extent, my lord, this Honorable Court will go into this? My lord, a bogey has been raised that I have not received the copy of the order. And everything is based on that bogey. So, my lord, the steps I have taken are correct. Today, the dues are to the tune of 2 crores. The supplementary bills received, not honored. This is the situation. Those are my submissions before you.
May I answer one after the
Yes.
other? The first and the most important allegation made against me is that on 19th of July, my lord has seen the date when the hearing officer has made his order. On that day, my representative went and signed. That signing is a part, my lord, of the assessment rules, which notes his appearance. The allegation of the corporation is, and I shall show you, lordship, how shockingly incorrect it is that I was served a copy of the order of the hearing officer on that day, and that now I am raising a bogey before the Court of Appeal that I have not received a copy of the order of the hearing officer. My lord, kindly come to my writ petition, my lord. I kindly come to paragraph 5, and I'll bear out paragraph 5 from materials on record in this court. My lord, page 4, may I just place? In the year 2017, however, the respondent number 1 issued 3 notices enhancing the annual valuation retrospectively to such and such, such and such, and such and such. The said assessments were void and unconstitutional. Upon receiving the said notices, your petitioners filed their written objections to the same. I have copies of the objections, Lord. I can place them before your lordship. Ultimately, a hearing officer of the respondent number 1 appointed under section 187(1) of the Kolkata Municipal Corporation Act 1980 confirmed the said valuations by orders dated 19 July 2017. Copies of the orders dated 19 July 2017 were not handed over to the petitioners by the respondent number 1 until the time mentioned hereinafter. What was handed over were 3 purported rate cards in Form F of the Kolkata Municipal Corporation Taxation Rules 1987, containing the final valuation confirmed, the period of effect of the said valuations, and the quarterly property tax and surcharge payable by the SSE. In this connection, copies of the said rate cards fraudulently described by the respondent number 1 as order under section 188(3) of the KMC Act are annexed here too. My lord, kindly come, my lord, to these rate cards. Please see, my lord, annexure P1. This is the first of the 3 rate cards. Kindly see, my lord, the caption on top. Order under section 188(3) of the KMC Act 1980 on determination of valuation. My lord, I ask myself, is this the order? This has been settled by Justice Bhaskar Bhattacharya's judgment, my lord, in N.D. Narayan Dev 21 years ago, and the corporation continues to serve this rate card And now it has changed the caption of the rate card saying that this is an order under section 188(3). It's on the basis of this that I have filed my appeal. So, my lord, Mr. Bishwajit Mukherjee is incorrect when he says that his client served a copy of the order of the hearing officer upon me. So when did I receive copies of the orders of the hearing officer? My lord, when before your lordships, my lord, we were not in a position to apprise actually what had happened and that the exact copy had not been given. My lord, then when the appeal was carried, in the appeal court for the first time, my lord, kindly come to annexure P6 at page 56. These orders are handed over to me. Now, my lord, I'm asking myself this question, my lord, in terms of the law laid down by this honorable court more than 20 years ago and settled and holding the field, which is the order of the hearing officer, my lord, I'm asking myself. That captioned rate card which I showed your lordship, my lord, as P1, or these orders which are actual orders? The answer to that has been given, my lord, in Justice Bhaskar Bhattacharya's judgment, my lord. I have brought it. The answer is the actual order of the hearing officer. The actual order containing its contents that is to be served on the assessee. And from that point onwards, his right to challenge starts and the corporation's right to impose demand starts. So, my lord, this was made available to me the day the appeal was disposed of by the Honorable Court of Appeal. As soon as I received this, I went back and I found that it was unreasoned. I immediately applied for review of the appellate judgment. My lord, kindly see, my lord, the review order again. I placed it on the earlier occasion. I, my lord, immediately applied for review of the appellate judgment. Kindly come, my lord, first to the appellate judgment once at page 59. Please bear with me, page 59. This records that the orders of the hearing officer was served on me on that day. Kindly come to page 61, internal page 3 of the judgment. Mr. Mukherjee, somewhere down the middle. Mr. Mukherjee, learned advocate for the corporation, has graciously made over copies of the orders of the hearing officer, which have been assailed in the 3 appeals before the Municipal Assessment Tribunal. Although he says that copies of such orders have been made over to the appellants. My lord, right. What has been made over to the appellants, my lord, are the captioned rate cards, which are captioned as orders. They were never copies of the orders. Now, my lord, after receiving this, we understood, my lord, that the corporation had by a single line order, keeping it close to their chest, unleashed a demand close to 2 crores rupees, my lord, on us. We immediately went up before the Honorable Court of Appeal, pointed out the fact that the order was unreasoned. Now, my lord, kindly see, my lord, in review, we went up before the Honorable Court of Appeal, and this is what the Honorable Court of Appeal had to say. Page 63, my lord, I have placed it yesterday. I won't take too much of your lordship's time, my lord. Kindly come, my lord, to page 65, internal page 3. The appeal court said, go and you prosecute your appeal. My lord said, go prosecute your appeal. We found that the order is a single line order, it's a nullity. We came back. And this is, my lord, my submission. Page 65, my lord, second paragraph. Mr. Banerjee, learned advocate representing the review applicants, draws our attention to the 3 orders, all dated July 19, 2017, passed by the hearing officer, enhancing the annual valuation of the property in question. He says that each of the said orders is completely unreasoned. The first order is to the effect, heard the AR, AV of 1894600 FNR being reasonable is confirmed. The second order is to the effect, proposed AV of such and such being reasonable is confirmed FNR. The third order reads, heard the AR, proposed AV of such and such being reasonable is confirmed. Mr. Banerjee says that an order of a quasi-judicial authority, which is completely unreasoned, is a nullity and non-est in the eye of law. He refers to the judgment of the division bench of this court in the case of the Calcutta Municipal Corporation versus Paresh Company, the one that I had cited for your lordship. But there are other judgments also, my lord, which say every order has to contain reasons. We are not concerned about the merits of the orders of the hearing officer, which are under challenge before the Municipal Assessment Tribunal. Mr. Banerjee says that his clients would like to withdraw the appeals and challenge the orders of the hearing officer in writ jurisdiction, since the same are completely devoid of reasons. Having heard learned counsel for the parties, we see no reason to review our order of March 15, 2023. If the review applicants are entitled in law to challenge the orders of the hearing officer in writ jurisdiction, after withdrawing the appeals pending before the Municipal Assessment Tribunal, they will be at liberty to do so upon notice to Kolkata Municipal Corporation. We have already submitted, my lord, applications in all 3 appeals saying that the orders being non-est, the appeals are also non-est. Therefore, my lord, it is not correct when Mr. Mukherjee makes his submission that copies of the orders of the hearing officer under section 188 were made over to me or to my representative the day the hearing was held. What was handed over was actually the rate cards that I have shown your lordship, fraudulently captioned as order under section 188(3). Now, my lord, the second question is whether I have filed a written objection. Now, my lord, in the dockets, if your lordship calls for, your lordship will definitely file my written objection. At least on 5 occasions, that written objection has been pleaded. Kindly see, not even once Mr. Mukherjee's client has ever said that there was no written objection. I would not have been heard if there was no written objection.
Did you not annex copy?
I have not annexed it because I didn't expect Lord Mr. Mukherjee to take this point
No, no,
today.
but then it should have been here. You have.
Lord,
annexed copy.
Lord, I pleaded it thrice, not only once. It's not a misleading pleading. Kindly see my appeals.
Where is the copy?
Lord, I shall
And,
come up.
the receipt that you filed your
Yes,
objection.
I've got a copy. I have objected to the valuations. I have got receipted copy to show that, my lord, those objections were placed on record. My lord, I do not have them right now, my lord. I can come up with a supplementary, but I pleaded this all throughout. Kindly see my appeals.
Your pleading will not do.
Yes, now that the point, my lord, I didn't expect the corporation to go this low. When it has gone this low, my lord, I will come and I'll disclose. Well, I'll disclose it, my lord. I'll come back on Tuesday, I'll disclose. Second, thirdly, my lord, and most importantly, he says that a bogey is being raised, my lord, regarding service of the copies of the orders of the hearing officer. He says, my lord, the hearing officer is not.
I'll hear you on Tuesday then.
Yes, my lord, may I come back with the written objections?
Heard submissions made on behalf of both the parties in details. Fixed for further hearing on Tuesday is the 27th.
My lord, I wanted to cite a few more judgments. Because of my lord's query on the previous occasion regarding my tax-paying history, I could not cite them. May I, my lord, exchange with Mr. Mukherjee in the meantime so that I can cite them?
Judgments on which point?
Judgments on the point of the awarding of reasons. I'll first show the written objection, then I'll show even otherwise is required to give reasons.
Short company, what else is required?
Yes, there are 2 other, my lord, Howrah Ganotantrik and Victoria Memorial, my lord. There, my lord, is clearly said, whenever
Take back this writ petition. Take it back.
My lord, may I just disclose them to Mr. Mukherjee and cite them on the next occasion?
Whatever.
Yes. My lord, KMDA's land, my lord, was reached out to the petitioner number 1 for the purpose, my lord, of erecting the Acropolis Mall. And, my lord, beside that, there's the Gitanjali Stadium complex, which the petitioner erected for the KMDA. Now, my lord, after that, before this lease was actually granted, pursuant to a competitive bidding process, before the lease was actually granted, the land of the KMDA, my lord, was assessed under the special provisions of section 176, read with section 171(8). That is, 5% of the cost of the KMDA's acquisition would be the annual value. This is a special provision which prevails over 174 in cases of land owned by KMDA. Therefore, my lord, that assessment was made from 2011-12. 29,420 was 5% of the cost of acquisition of KMDA. Thereafter, my lord, the lease deed was granted. After the lease deed was granted, from the quarter next following the date of grant of the lease.
Lease between KMC and your clients.
KMDA and my client.
KMDA.
Land owned by KMDA. Lease deed granted in favor.
KMDA is not a party here.
No, KMDA need not be a party. There have been the my lord, earlier orders of this court. So, my lord, this land was assessed at 29,000 and odd. That is 5% of the cost of acquisition of KMDA from the government. And taxes were being paid at all material times. Now, my lord, after the deed of lease was made, my lord, there, my lord, were 2 assessments which were proposed, my lord, by the Kolkata Municipal Corporation. Treating the deed value, which is the lease premium, the highest bid premium, as market value for the purpose of section 174. They assessed me at annual values based on that. Now, my lord, this couldn't have been done in my submission because, my lord, these are lands still owned by the KMDA. The matter was squarely covered by a judgment of this honorable court in Fabworth Promoters. Honorable single bench had held that this could not have been done. There's a special provision that has to be followed. That matter went up to the division bench, that was affirmed. And from there, my lord, the matter has traveled to the Supreme Court where it is pending. but there is no observation of the Supreme Court whittling away the precedentary effect of the division bench's judgment. Now, my lord, we took that objection before the municipal commissioner, saying that you can't assess us under 174 at all. Municipal commissioner sat over the objections, sent it to the hearing officer. We came up before your lordship. Your lordship was pleased to say that the commissioner should decide this matter and the specific objection raised as to applicability of 176 and 171(8). Now, my lord, an appeal was carried from that order. The Honorable Court of Appeal, my lord, maintained your lordship's order, said that in the event the municipal commissioner decides anything adverse against you, you are at liberty to come back to the writ court, because not a question may be raised that you have to go to municipal assessment tribunal because the commissioner is exercising jurisdiction of a hearing officer, etc. So that was clarified. The appeal court said, if anything adverse is decided against you, please come back before the writ court.
And that is the reason you are here.
No, my lord, thereafter we went to the municipal commissioner. The municipal commissioner, my lord, was directed, my lord, within a time-bound period to decide it. Not kindly permit, my lord, Mr. Mitra to take over, my lord.
Banerjee has placed the facts. Lordship, kindly see the division bench order, page 102. It starts at 103. Lordship, that 102 it starts. Second, last para of 103, after referring to the we are not inclined to go into the merits of this between the parties at this stage. Since a representation has been made by the appellants, let such representation be disposed of as directed by the learned signature. We clarify that the appellants will be at liberty to rely on all such materials as may be advised, including decisions of courts. We do not interfere with the order of the learned signature as we do not find any apparent infirmity. However, in the event the representation of the appellants is rejected or any other adverse order is passed, same shall not be given effect to, and or the assessment shall not be proceeded with for a period of fortnight from the date of communication of the order of the appellant. This is to give the an opportunity to the appellant to challenge any such adverse order before the appropriate forum. So they have to dispose of my representation as to whether this is 171(8) and 176 apply or not. And then only they can proceed to go for the rest of the assessment. Now, what is happening is the learned commissioner, we have placed the judgment, but he is going on, he's not taking a decision on that. On the contrary, if your lordship kindly sees page 136, the last 2 days I will show order. 136, last paragraph. Mr. Banerjee was there. Last week, he also contended a similar case, division bench of the Honorable High Court set aside the valuation by KMC. Though the matter is now pending at the Supreme Court, in absence of any stay order, even if there is a stay order, KMC cannot adopt a valuation method that was set aside by the Honorable High Court. Then, my lordship, Assessment and Collection Department submit that section 176 stipulates the annual valuation of. So take a decision whether this will apply or not. Because if that applies, then the 29,000 valuation remains. Now, what thereafter goes on, submit that 176 stipulates the annual valuation of land and building belonging to every statutory body based on the cost of acquisition. This is natural since acquisition cost is the actual cost of statutory bodies. However, when such land is further leased out to a third party, the cost would be the deed value plus incidental expenses. The cost to the petitioner, therefore, is the deed value plus cost of construction of the stadium. So this should be treated as the consideration value. Now, lordship, you see the next paragraph. Assessment Collection Department KMC is directed to submit their written statement within 1 week. The petitioner may also file their supplementary submission on the written representation, if any, within next 7 days. They should also provide the cost of construction of stadium. Whether it will be the acquisition cost, my acquisition cost, or the KMDA's acquisition cost. Let him take a decision on that. Same thing, lordship, will see the last day also, page 140, 29th April, 140 at 141.
Yes, 20th of May was the date fixed.
Yes.
Was it hard?
No.
Thereafter,
It was adjourned. But then again, I have to disclose my my cost of construction of the stadium. Well, let him take a decision. That is the direction of the appeal court. He has to follow it, right or wrong. That is our High Court decision, your Lordship's decision, and reaffirmed by the division bench that he has to
No,
take.
but then he will take a decision provided you place all documents that are
Well,
required for the purpose of taking a decision.
Well, for the purpose of taking a decision whether this is 176 will apply or not. That's the only thing under consideration. Lordship kindly sees once more the order at page 103. 103. Since a representation has been made by the appellant, let such representation be disposed of as stated by the SINHA. Well, to take it that I will not give my acquisition cost. If take it, so whether 176 will apply, 171 will apply, my cost of building the stadium, assuming that I am refusing. Let's take it without meaning any disrespect but then he has to take a decision on my representation. That is page 103. My representation is that only that 176 applies, 171, 8 applies. So this is the cost of acquisition of the KMDA. Let him take a decision. If he holds that no, it is not KMDA's cost of acquisition, but your cost of acquisition, then I will challenge that decision. And if the court also holds it, then I will face the consequences. But they have to take a decision on that. He just can't sit on my representation. I have certain documents to give. I have given it. It is like like your Lordship, like if the pleadings are there. It is then let him take a decision on my representation, whichever way, either way. If he holds that it's applicable, as in 176 does not apply, I have to go by my cost of acquisition, then law will take its own course. But then here we have come back to where we were before the earlier writ petition, before the Lordship's order and division bench order. The division bench has specifically said you first dispose of the representation. Pause for a fortnight, then you proceed further. So let him take a decision. I have submitted what I have to submit. The court says 103 last paragraph, we clarify the appellants will be at liberty to rely on all such materials as they may be advised, including decisions of court. I have been advised, rightly or wrongly, Lordship, my lawyers there to confine to these Fab judgment and the Justice Mathre's division bench, Justice Kaur-Gupta, Justice Banerjee, the 3 judgments, and Supreme Court. I have now so I have decided what I have been advised to rely upon. Page 103, last 3 lines. So that the commissioner cannot say that I will not decide. Let him hold against me, because I am very confident here, because there are several judgments even after that. Even in this group, I have got another judgment that is cannot apply. There's an amendment to the KMC Act that's held to be prospective. So, Shugotona, South City.
So
Another case.
You are over.
That's all.
For the assessment of annual valuation. There they objected that the proceedings cannot be initiated because of certain reasons, because of certain legal questions, certain legal certain facts. Now they filed a writ petition before the Lordship my lord, then the Lordship my lord was pleased to hold that since the representation is there raising an objection to the proceeding, therefore that is to be heard out first. Therefore, there should be a logical conclusion on the representation in the proceeding. Then, my lord, they did
No, representation is pending. He wants a
the
direction.
representation is pending to what extent, but regarding in connection with the assessment of annual valuation.
Whatever is the extent.
Therefore, I am to take a logical conclusion that he cannot interrupt at the midst of the stage. He cannot stop it, my lord, that I cannot, because I have not taken a decision.
No.
Of course, my lord, the decision to be taken on his representation, he cannot take recourse to the order of the division bench simply because this is the division bench order speaks of after conclusion of the proceeding, not at the mid stage, not in the midway that he can come to the court to stall that I cannot require. If I require something when in the process of doing something in the conclusion, then my lord, if he satisfies, if he considers that I shall not submit it, then the matter will be proceeded accordingly. But he cannot say that I will not supply and you cannot ask for before the conclusion of the proceeding. Therefore, I am submitting to your lordship, my
The
lord.
division bench did not fix any time limit within which it has to be
Division bench, my
considered.
lord, has not, my lord, fixed. Lord, division bench rather giving him time that after the decision, some protection has been given, not to give effect to that order for, my lord, to have a limited period, so that he could, my lord, approach the appropriate forum. Now, the thing is this, it is to be logically concluded. After the division bench order, I am respectfully submitting, my lord, he cannot approach this, my lord, court, my lord, until and unless the proceeding is concluded. Therefore, I may require, if your lordship, my lord, while considering a proceeding, your lordship may require, my lord, anything your lordship chooses to consider the disposal of the matter. But whether, my lord, it is required or not, that is up to the parties concerned. If I take into consideration, he can say that I should not have, or I ought not to have considered. Therefore, my lord, it should be logically concluded.
The grievance of the petitioners is that the Commissioner, Kolkata Municipal Corporation has kept the representation filed on their behalf pending for a considerable long period of time and has not disposed of the same in terms of the direction passed by this court. Stop paragraph. It appears that the Honorable Division Bench of this court, by an order dated 20th March 2023, passed order in MAT 420 of 2023 with IA number CAN 1 of 2023 in the matter of Merlin Projects Limited and others versus Kolkata Municipal Corporation and others, was pleased to direct the Commissioner to consider and dispose of the representation made by the appellants on 24th December 2019. Stop. The appellants were given liberty to rely upon all such materials as may be advised, including decisions of court. Stop. The court further directed that in the event the representation of the appellants is rejected or any other adverse order passed, the same shall not be given effect to and/or the assessment shall not be proceeded with for a period of fortnight from the date of communication of the order to the appellants. Stop. The same was to give an opportunity to the appellants to challenge any such adverse order before the appropriate forum. Stop. Next. It appears that in compliance of the direction passed by this court, hearing has commenced before the Commissioner. Stop. The matter was heard on 2 occasions. That is on 30th of March 2023, when the next date of hearing was fixed on 29th of April 2023, and thereafter it was again heard on 29th April 2023, and the matter was adjourned on 20th of May 2023. Stop. Paragraph. The grievance of the petitioners is that the representation is yet to be disposed of.
The next date is tomorrow.
And the next date of hearing is tomorrow, that is 24th of June 2023. Stop. Next. The petitioners contend that the Commissioner should decide the representation on the basis of the documents that are already documents which have already been placed before the said authority. Stop. Next. Learned advocate representing the KMC submits that the matter is under active consideration of the commissioner, and the petitioner ought not to have approached this court in the midst of the hearing process. Step. The commissioner ought to take time. No, the commissioner will decide the representation on the basis of the documents that may be required from the parties, and the petitioner ought not to have rushed to court to forestall the said hearing process. Step. Next. It appears from the submissions made on behalf of the parties that the court disposed of the appeal on 20th March 2023. Stop. The commissioner initiated the hearing process immediately thereafter. Stop. The matter was heard on 2 occasions, and the commissioner requires further documents for effective conclusion of the representation filed by the petitioners. Stop. The commissioner may proceed to conclude the hearing upon calling for the evidences that may be required for coming to a logical conclusion of the representation filed by the petitioners. Stop. Next. Endeavor shall, however, be taken to ensure that the representation is disposed of at the earliest. Stop. Since the Honorable Division Bench, they did not fix up any time frame within which the appeal is required to be disposed.
The Honorable Single Judge, my lord, has
The-
12 weeks had been given.
This bench is accordingly not fixing up any time limits, and the commissioner will take a decision in the matter pursuant to all orders passed by this court. Stop. Next. The parties will, however, be obliged to produce documents as may be required for effective consideration of the dispute pending consideration before the commissioner. The court also notices that the petitioners are adequately protected by the order passed by the Honorable Division Bench and Division Bench, whereby the court directed the corporation not to proceed with any adverse order if passed against the petitioner in the representation filed. Stop. In view of the above, there is in view of the above observations, the writ petition stands disposed of.
Oblige.
Service taken on record. এসবে বলতে পারছি না, আপনি 3:30 আসছেন। প্রদীপ কি আসবে না? তো কালকে দেখলাম অনেক রাত্রিরে আমি আর আপনাকে রিপ্লাই করতে পারি। আমি তো দেখলাম রাত্রি 11:30টার পর মেসেজ ঢুকেছে। প্রদীপ আজকে আসেনি, তো আসেনি।
Lordship, in one of the writ petition, wherein your lordship has directed the Bureau of Immigration to furnish one
Yes.
report, lordship, that order has not been uploaded yet, lordship. Some inadvertence has been.
বলছে একটা অর্ডার আপলোড হয়নি।
The matter is likely to be taken.
তো দেখুন যাতে পাওয়া যায়।
Lordship.
আর আমাদের iOS এতেও দেখা যাচ্ছে না। iOS এ দেখি নম্বরটা দিয়ে দেখুন না, তাহলে একটা প্রিন্ট আউট সঙ্গে সঙ্গে বার করে দিয়ে দেওয়া যেতে পারে। Please see whether it, because I have signed the order immediately.
The only difficulty is that Lordship, since I have to communicate, I have
One minute,
already
1 minute.
communicated.
নাম্বারটা দেখে একটু বলে দিন তো। If it is available in the iOS, then it will be immediately handed over to you.
Lordship, I'm grateful.
Call the list.
And I'm for the petition and
Lordship, I am for the state, Lordship.
that matter, my lord, your lordship had called for a report from the video, my lord, this is clearing of that canal, that matter.
Okay. এদিক থেকে দিন, ওখান থেকে আমি নিতে পারবো না। Who is for the
Lordship, I am
state?
for the state, Lordship.
Yes.
Lordship, as on date, Lordship, this is what I have received from the BDO, Lordship. Lordship, the order has been passed on 2nd of August 2022, Lordship's order. Immediately, the Pradhan has communicated to the BDO as well as the Zilla Parishad to supply the funds because they were out of pocket. Lordship, then the first page, Lordship will find that the BDO has immediately communicated to the Zilla Parishad asking for funds because the BDO is not the authority to provide the amount, Lordship. It has to
Madam,
be.
you are representing the state respondents. You
Yes, Lordship,
represent
but-
the BDO as well as the
No,
deputy
Lordship,
secretary.
no, Lordship. Zilla Parishad is not represented by the state authorities, Lordship.
Very well, the state government is there. The BDO does not have the fund. The Jila Parishad does not have the fund.
No,
Where from
Lordship,
will the fund come?
Lordship, the BDO has sought for the fund from the Zilla Parishad because
Yes,
the
the BDO,
fund has to be with the Zilla Parishad. They are the authority who has to release the funds. BDO doesn't have the power to release the funds, Lordship.
the BDO, the Panchayat Samiti, the Zilla Parishad, all three tiers, they do not have funds.
Lordship, the
They should be called in court, my lord, to explain their conduct.
Lordship,
Let the.
as on date, the BDO doesn't have the authority to release the fund. Whenever the Zilla Parishad will release the fund immediately, Lordship, the BDO has
Where
sent
is
the
this
estimate.
sent?
Lordship,
Call him. I'll pass it over.
Lordship kindly keeps it at 115 or one.
No, there are other matters. Call him immediately. Next matter.
Lordship, I beg to appear on behalf of
I am for the
Secretary of
petitioner,
Investigation. Lordship, I am being led by learned deputy solicitor in this matter. Lordship, pursuant to a lordship's
Your
previous order-
client has received.
Lordship, we have copied. It was done on 21st, Lordship. It started on 19th and it was completed on 21st of Lordship.
When is the matter returnable?
Lordship,
On
14th of July.
14th of July.
Lordship.
Very well.
In pursuance of 14 June order, my lord, may I indicate one thing, my lord? And this is regarding all electronics record, my lord. Whether the 65B certification is there or not, my lord,
It
kindly
has
take,
been given.
kindly take care.
The Registrar General has given it.
Extremely grateful, my lord. I just indicated.
No, it's there. Please come. it has been submitted by the learned advocate representing the Central Bureau of Investigation that the copying process of the CCTV footage has been completed and the footage is presently available with the Central Bureau of Investigation. Stuff. Next. Certificate to that effect has also been issued by the Registrar General of this court. Stuff. Next. The writ petition is returnable on 14th July 2022. Stop. The authorities are directed to act now to proceed with the investigation and file report on the adjourned date. Yes. It's always there. Where is the difficulty? And liberty to mention. Returnable on such and such date, liberty to mention in the event 14 July tarpore. Liberty to mention in the event the interference of the court is required at any stage by any of the parties.
Extremely good.
Please, Your Lordship, my lord. I appear for the petitioner. I mean, led by Mr. Bhattacharya, who's online, my lord, if your ladyship will.
Led by Mr.
Vikas Ranjan Bhattacharya.
Yes, yes, yes.
But kindly come to the order at page 39. That an ex parte inspection was done on the basis of this.
I am saying only kindly fix the matter on Tuesday, my lord.
State respondents.
My lord.
What is the requirement of the state? The Chandanagar Municipal Corporation is here.
My lord, just like what you have seen.
Yes.
Just like what you
Yes.
have currently appearing.
Please wait. I'll hear the petitioner. I have followed it. No, wait. Please wait. Why is it appearing as to be
But
mentioned?
I had mentioned the matter yesterday, citing urgency, because we got to know that the police has written to the municipal
All right.
corporation saying I'll demolish before 26th.
All right, I get it. Yes, Mr. Bhattacharya.
Well, kindly come to the order at page 39.
39.
I will not place the order in detail, but kindly see what is the alleged unauthorized construction which they are complaining of, and whether this can be said to be at all construction. Page 40.
Yes.
Page 40, the penultimate paragraph, the unauthorized construction which has to be removed within the above stipulated time, namely one kitchen shed measuring about 100 square feet. This is not an RCC construction. A shed, one glass top shed measuring about 115 square feet on the second floor. One CI shed measuring about 453 square feet. These are all sheds. These cannot be said to be construction within the provisions of the Municipal Corporation Act. And then say that this is wrongly used. Nevertheless, if it is used under user by wrongly, that can be remedied. But these are not the structures which can be said to be structure under the purview of the Act and can be demolished. Now, this requires to be considered. Whether the shed can be said to be a construction under the Municipal Corporation Act.
What about the change of user?
Change of user, for that there is a provision to regularize it. But for that, the structure demolition is not called for. The only grievance I find, they say the ground floor ought to have been open. There you have a shed. This is the change of user.
If something is meant to be kept open and you have
Yes,
covered
therefore,
it.
I have covered, this is not a permanent structure. This is a shade, like sunshade. Now that if the change of user is the violation, there is a provision to regularize it.
it is
Not
not a sun shade. It is a kitchen that you are operating as the restaurant.
Yes, with the permission of the municipal corporation that we have been operating. We have the permission also. My junior will show you the permission granted by them.
Maybe the license, but that does not mean the permission to run a restaurant.
The
at
license,
the top of a building.
the
where-
license cannot be granted unless because the permission is granted by the municipal corporation.
Yeah, I understand.
But this requires consideration. Like these, they are suddenly requisitioning police to demolish it. That not is something harsh.
Why did you not make the private respondent or private
By
respondent?
everybody's party, they have been served
It
also.
served everybody yesterday also additionally by hand.
But then thing is, they possibly may not know that the matter will appear today.
No, my lord, we have under covering letter mentioning that we mentioned it, it will appear we served again by hand yesterday, my lord.
Like we will serve
To the
And-
private respondent, because my lord, speed post in the course of the day would
Yes,
not.
I understand, and the private respondent accepted it.
Yes, yes, ma'am. Both of them. There are two, my lord, both of them have accepted, my lord, the affidavit of service is also ready.
Very good.
The petition. The petition is the tenant.
Hmm.
The owner has not come before the Lord, challenging the order first.
And the construction has been made by the tenant.
Owner. Owner.
Construction has been made by the owner.
No, I run my business there. I am the affected party. I run the business there.
I cannot follow.
Construction is made by the owner.
Construction made by the owner.
He has been heard by the corporation.
All right.
Order has been passed.
All right.
That order, no step has been
And
taken
he
by
is the tenant in that portion of that construction.
running the business illegally, my lord.
All right, Rani. You granted license to him?
Only for the middle 704 square feet,
No.
not beyond that. Not for the kitchen he is using at the ground floors, not for the rooftop restaurant he is using.
Rooftop. Why don't you cancel his license?
Only that will be done shortly, madam. After giving hearing to him, madam, it will be
Yes, take whatever steps you are required to take under the law. In the event the business is being running in an illegal manner, but then that's a different issue.
obviously done.
That is a different issue. What about this 100 square?
Be temporary or permanent. I'm not saying that it's temporary. But yes, enclose the open space as shown in the
Plan.
building plan, madam, the extension. Nothing can be done in violation of that building plan, madam. The owner who has made this construction has not come. Give a lot of tell him that order. He's not agreeing.
He cannot be agreed, but ultimately it affects me. It affects my business.
No, but then the owner of the premises.
Owner is
made-
also a party. Owner is also
Owner
a
is a
party.
part. And that is the reason the owner accepted the service by hand
Ah.
and is not appearing because he knows that the
Yes.
interest of the owner is
He
being
knows,
taken care of by the tenant.
no, he knows if he appears, he'll be difficulty. Because the difficulty between municipality and him is a personal war, and I am the victim.
You're not only the victim, if you raise construction, then any
but-
construction beyond the sanction plan, you are
Absolutely
required
right.
to obtain.
But I do not contest the proposition. Any construction beyond the sanction plan is bad. But I do not contest that proposition. But whether a shade, temporary shade could be said to be a construction. But let the municipality have a further inspection to find out this temporary shade or permanent shade. So this is no, the ground floor is not covered with a permanent structure.
Section 259 F, my lord.
Wait, I have the book here. বই আছে তো আমাদের।
But kindly come to the definition of building. Definition of building clause, section 2(7). That would make the definition clear.
Yes, 2(7).
Building means a structure constructed for whatsoever purpose or whatsoever materials and includes foundations, plinth, wall, floor, roof, chimney, fixed platform, veranda, balcony, cornice, projection or pursuance. So these are all permanent. Then and any wall other than boundary wall or less than 2 meters in height on the roadside, having the solid portion not exceeding 1.5 meters in height, enclosing or intended to enclose any land, sign or outdoor display structure, but does not include a tent, shamiana or tarpaulin shed. Therefore, it's not a building within the meaning of this section. But it requires consideration. Well, at the prima facie stage, it requires consideration. Whether this Shamiana could be said to be a structure within the meaning of the act.
It is not a Shamiana, it is a
Temporary shade. Shamiana is also temporary shade.
Two-
And tent. Because if
259.
motor- They call it tent, including a tent. Shamiana or tarpaulin. Now, ultimately, it comes to the position that this is a permanent structure, we'll remove it. We have no hesitation removing if anything is wrongly done.
Which portion?
1F, my lord.
1F.
Of
259,
Section
1F.
259.
259, 1F.
259 1F. Yes.
The area covered by the private respondent
Hmm.
have shown in the building plan was open space. They have encroached it.
Yes, let us also read this 1F. In this chapter, unless the context otherwise requires, the expression building means F, to roof or cover an open space between walls or buildings to the extent of the structure formed by the roofing of or covering of such space. So how does it come within this inspection report? It doesn't come within this.
No, because you have made the shed
Two buildings.
covered. You have covered that open space. The roof is meant to be kept open. You have
Yes,
covered.
that is the violation for
Yes.
change of user.
No, not only
That-
user. User is something else. User
Deviation from the
means
building plan.
a roof, it ought to have been kept open, vacant for everybody. You
No, but
make
Rosh
a
will kindly
picture of
read with me. Milo will kindly read with me F once again. I may be
Yes.
wrong, but to roof or cover an open space between walls or buildings to the extent of the structure formed by the roofing or covering of such space. Now, this should be a covering, Millard, between two walls or two buildings. That is, Millard, called the structure under the building definition.
Kitchen is as my learned friends.
Kitchen is at the top. It does not cover two
Ground
buildings.
floor. My lord, as per my instruction, kitchen is a ground floor between two buildings, my lord, encroaching the open space, and rooftop is being used by the petitioner as restaurant.
kitchen is in the ground floor enclosing two in
Yes,
the
open
common
space.
space.
Yes.
The open space has
Yes,
been.
and rooftop is being used as restaurant, open.
Rooftop doesn't come under this construction. The ground floor may come if it is shown that the
That's
covers
not
two
allowed
buildings.
to be used as for commercial purpose. There is no permission to use the rooftop.
No, that permission is there. Permission dekhi dao.
When are you taking steps for demolition?
My lord, and we actually sought for police help, my lord. Yesterday, police has given a letter asking for the date or between 12th to 22nd to 26th, my lord. Since the matter is pending, we have not communicated the date.
You have communicated.
No, we have not communicated.
You have not
Since this matter is
communicated.
pending
Since
before your
matter is pending. We'll hear it. Today it's appearing as to be mentioned because there was some urgency. So we'll hear it immediately after this panchayat matters are over.
That could be best.
Today
So-
itself, man.
No, not today. It will not be possible. After 2 weeks or something. After the panchayat
Matters are.
elections are over and everything, please come.
Ms. Solok, there is a matter is pending. Corporation does not take any step. No.
Please come. The matter has appeared in the list under the heading to be mentioned on the prayer made on behalf of the petitioner that the corporation were taking urgent steps for demolition of the alleged unauthorized construction. Stop. Next paragraph. It appears from the order passed by this court on 15th of June 2023 that the writ petition was made returnable on 26th of June 2023. Stop. Next. The it appears that an order of demolition has been passed by the Chandanagar Municipal Corporation on 18th of April 2023. Stop. The petitioner is aggrieved by the same. Stop. I have heard the submissions made on behalf of the petitioner as well as the corporation. Do you think corporation that a further inspection will be required?
It is not required, madam.
Not required.
The owner is not aggrieved.
Very well. If you have all facts
Records,
and
ma'am.
figures, then it is all right. Acha. Let the matter appear in the list under the heading for orders on 19th of July 2023. Stop. The learned advocate representing the corporation has assured this court that the corporation will not proceed to implement the order of demolition without the leave of the court.
May we file the affidavit of service?
Affidavit of service taken on record.
Grateful.
Lordship. Lordship, item number 1, Lordship asked me to,
Yes.
Lordship asked me to ask Mr. Shen to personally appear, Lordship. He has not come to court today, Lordship. Item number 1.
I'll make it not today. He'll be coming on Monday.
Yes, Lordship.
Yes.
Grateful, Lordship.
I am for the corporation.
May be granted liberty to file a supplementary.
Liberty to file supplementary. Why?
Because, my lord, I have not been served with a copy of the order. That part, my lord, I had not taken in the original petition, my lord. Only on one ground, my lord, to be added.
Ground.
Ground means
Copy of the order of.
demolition. There's an order.
You have not been served.
We have served, madam. G+1 building
I'll tell you, Lordship,
sanctioned and 4 floors extra, madam.
very well, my lord. Whatever.
G+1 building,
No, no.
4 floors extra.
Yes, I know that, my lord. Ultimately, I will be under the guillotine. I just want to ensure that I can exhaust my statutory rights, if any, and then face, my lord, the guillotine. I have materials to show that I had applied for all the 5 floors. I have materials to show that they are within sanctionable limits. I have materials to show that the corporation did not sanction it because they awaited completion because their earlier board meeting was not complete. But, my lord, those are questions of fact. I will not disturb the writ court with that. My lord, I have received this. That's page 77 at annexure P4. Please see, my lord. This, I say, is not this is not an order. This is not an order because the person concerned is the commissioner. The commissioner, my lord, can delegate his judicial duty. He cannot delegate his quasi-judicial duty to anyone. This allegation is dehors the records because my records would show that I have made applications. My constructions are within the permissible limits. Now someone needs to hear it and finish it off. Now it appears that the corporation, that the commissioner has heard it and finished it off. That's page 79. Please see page 79. As directed by the Commissioner, HMC Vide is order dated 2nd June 2023. You are hereby directed to vacate the unauthorized portion so that I can demolish within 7 days. Now, my lord,
And the demolition order is there in the supplementary.
no, in the supplementary, I have said that this order is not with me.
2nd of June 2023
Not-
order is not with.
Not with me. So I need the order and
Where, did you appear in the hearing?
yes. I've appeared in the hearing. I showed cause pursuant whereto an order was required.
Are orders supplied or you are to obtain certified copies
So
of
these
the
have to
same?
be supplied, my lord. There's my lord a division bench of your lordship's court that there's a latent and patent obligation to supply copies of the orders of the special officer.
Construction that is deleted.
That is a self-demolition notice. Now we will not supply.
That's a
any other-
notice. That's a notice.
That is self-demolition.
So I am not.
Yes, that is the actual order.
Oh, that cannot be the order.
Yes, this is our. We have served them a self-demolition notice. Thereafter, we will not serve any other further. We have
No, they
served
need
them.
not. But-
Then we have served
No,
them
no,
a notice
see
to
177.
vacate.
My lord, my lord.
Yes, 1 minute.
Yes, only.
G+5.
Yes.
G+4?
No.
They are saying
G+1
plus-
sanction and
They are
2,
saying
3,
G plus
4,
five,
5.
please. 2, 3, 4, 5, they were.
Four floors are
Hello,
being
may I,
erected.
my lord, finish once, my lord.
Yes,
Please,
yes, you
please
finish.
permit me, my lord, to finish.
2, 3, 4, 5.
2, 3, 4, 5, they say are unsanctioned. I say 2, 3, 4, 5 are within permissible limits. I had put in the plan. I
I
put
do
in the plan.
I do not know anything about
That's
permissible
all right.
limit.
My lord,
whether
I am
it's
not on
sanctioned or
anything else.
sanctioned.
I am not on any.
Sanctioned or not
My
sanctioned?
lord, I am not on anything else. I'm only on one thing. There is a procedure given, my lord, under the statute that an order of demolition is made and it has to be served on me, my lord. If it is served on me, I have a forum. I have an appellate tribunal under the statute. That tribunal is non-functional for the last 30 years. Therefore, my lord, sometimes we come up before your lordship's court, my lord, in writ jurisdiction to substitute the role of the tribunal. Now, only thing that I am before the writ court today is for this purpose. Kindly, my lord, let that final order which has come in, where my submissions ought to have been recorded, everything that I brought on record ought to have come up. Let that.
You make an application, they will
These
serve it.
cannot
Very
be
well, I'll do
permitted, my
that.
lord.
I'll do that.
No, my lord. I have taken instructions that after second floor it is in dangerous
No,
condition.
Mr. Banerjee cannot. My
Second,
lord,
third, fourth, and fifth. 4 floors.
No,
my
no,
lord.
there are
There is no
23
stability
families.
And they have at their own erected the building.
Nobody
4
is
floors.
passing any order of stay.
No, my lord.
I am passing direction upon you to supply the certified copy of the order of demolition in case
Order of
application
demolition is
made.
this, my lord. We have no other order. My lord, if you complete, then
My
I'll
lord,
come.
may I show the statute for a
No, I am
may I
there
just
with
show
the
the
statute.
Yes, my lord,
I am
kindly
there
see
with
the
the
Howrah.
statute.
What am I
Self-demolition
saying?
notice is being
No,
served.
what am I saying? No, this cannot happen.
Yes.
How can the Howrah Municipal Corporation?
We cannot prepare a new law.
My lord, may I
normally follow
just show,
this.
my lord, your lordship, my lord, 177. Please
you're-
see 177 and
Yes,
please
I am
compare it
with
with
the-
400.
I am
And may my learned friend, my lord, kindly give me, my lord, your lordship's audience for a minute.
But then
As
you
you-
also don't raise your voice.
Lord, I am not raising my voice.
In this manner, they are raising their voice and trying to authorize
won't
the
help.
extra 4 floors.
I am not wanting, Lord. How can I raise my voice and succeed? If I raise my voice, I'll fail.
Not before this bench at least.
Logic will abandon me, I'll fail. Before anyway.
Yes, 177.
Kindly see 177, just once. What am I on and what is my learning?
177 1.
Yes, what is 177 saying?
5. Order of demolition.
Where the erection of any building or the execution of any work has been commenced or is being carried on or has been completed without or contrary to the sanction referred to in section 175C or in contravention of any of the provisions of this act or the rules and regulations made thereunder, the commissioner may, in addition to any other action that may be taken under this act, make an order directing that such erection or work shall be demolished by the person at whose instance the erection or the work has been commenced or is being carried on or has been completed within such period not being less than 5 days and more than 15 days from the date on which a copy of the order of demolition with a brief statement of the reasons therefore has been delivered to such person as may be specified in the order. Provided that no order of demolition shall be made unless such person has been given by means of a notice served in such manner as the commissioner may think fit a reasonable opportunity of showing cause why such order shall not be made. Now, Lord, kindly see subsection 3. Any person aggrieved by an order of the commissioner made under subsection 1 may within 30 days from the date of the order prefer an appeal against the order to the municipal building tribunal appointed under section 181. Now, my lord, there is no municipal building tribunal, my lord, under section 181. But my lord, kindly see the KMC Act once, section 415.
No, tribunal is not there. Y'all are coming over here. It's all right.
Kindly see
There is no
415.
difficulty.
So,
I am
there's
placing-
nothing more to it. Lord, kindly see, Lord, 415 of the KMC Act. Just once. The Kolkata Municipal Corporation Tribunal is supposed to be, Lord, a multi-act tribunal. Kindly see, Lord, 415, Lord, of the KMC Act. Just once, my lord, for my satisfaction. My lord.
Yes.
The state government shall appoint a minimum 415.
The tribunal is not functional in Howrah.
No, but then the Kolkata one can stand in as a tribunal for all the acts.
You go and
But now,
file proceedings
my lord, I'm
tribunal,
placing that
which is
judgment.
working. If it is not for, if you say that the KMC tribunal can hear out the matter, you go there.
No, but
Who
the
is
state
stopping
government
you?
will have to just give a nod. Kindly see, Lord, the
If it is not there,
Yes.
If the state has not yet given a nod, right, then what will you do? You cannot be left remediless.
So therefore, my lord, 1 year cannot be denied to me. I need a
No.
factual forum.
In the
Go before the
Kolkata
appropriate
Municipal
forum.
Corporation Act has also been considered
get
by
a copy?
Honorable Supreme Court of India.
This is
And
I'm
what order has been passed, my lord, I can show
saying.
that any prayer for regulation or anything after the completion of the construction, unauthorized construction cannot be allowed to be done.
No, no, he's
That
on
has been
merits.
taken considered.
He's on merits. Now, my lord,
Yeah.
may I just, my lord, distinguish the judgment once?
No. Page 77 is the order which you say is not an order of demolition according to the corporation. This is the order of demolition. The court is not interfering in the matter.
No, he says it's a
Whatever.
self.
Yes, that is self-demolition. That is explained in 177.
No, my lord,
Then
will
I can
not-
again
my
read.
lord, I'm asking myself this question, my lord, with great.
This
respect.
by an demolition order, the
There's a
party.
demolition order that has to be made and should be
Yes, no.
given to me.
No.
I have to be
Party
given the
will-
opportunity, my lord, to assail that order.
This is Deepak Mukherjee.
Deepak Mukherjee.
Deepak
Yes.
Mukherjee
That has
was-
been taken care of in a
Mukherjee was
Kolkata
Rule
Municipal
26.
Corporation matter, my lord.
That was Rule 26.
Kolkata Municipal Corporation matter. My lord, what happened? But in the 177 notice, it is said that self-demolition notice is given to the party. Thereafter, no other demolition notice required.
And how can the assistant
The-
immediate pass an order? of
Yes,
demolition?
that
It's a
has a-
notice.
The,
That also I can show judgment. In a division bench, it has been confirmed. Delegation is valid.
The final order has
the
to be given.
petitioner is aggrieved by the communication dated 29th of March 2022. This is two.
No, 2nd June 2023, my lord. That was the notice. Please come to, my lord, page 79. That's, my lord, my anxiety.
That notice is given to the police
Page 79. What?
for police help. No further notice is given to them. Request to be
That's
given.
an order, my
Petitioner
lord.
is aggrieved by the communication dated 16th of June 2023,
It's of an order of the commissioner.
whereby the petitioner has been directed to vacate the subject premises at 46/1, 3 Kori Nath Bose Lane, PS Golabari, Ward number 10, under jurisdiction of Howrah Municipal Corporation, for allowing the corporation to proceed with the demolition process, which may be carried out, which is to be carried out by the corporation within 7 days from the issuance of the letter. Stop. Next. The aforesaid communication speaks about an order of the Commissioner, Howrah Municipal Corporation, dated 2nd June 2023. Stop. The learned advocate for the petitioner submits that the order of demolition was never served upon the petitioners, and accordingly, the petitioners are not aware of any such order of demolition being passed. Stop. The petitioner accepts that a notice of self-demolition dated 29th of March 2022 was issued by the Assistant Engineer, Howrah Municipal Corporation, wherein the petitioner has been directed to cause self-demolition of the unauthorized construction of the 2nd, 3rd, 4th, and 5th floors of the subject structure, which were constructed beyond the sanctioned G+1 structure. Stop. Next. The paragraph, the learned advocate for the petitioner submits that the petitioner intends to prefer an appeal against the order of demolition. But as the order of demolition has not been served, accordingly, the appeal cannot be filed. Stop. Next. Learned advocate representing Howrah Municipal Corporation submits that The petitioner was afforded an opportunity of hearing to defend his case. Stop. The construction in question was sanctioned only up to the G+1 story. Stop. The petitioner raised 4 additional floors, that is the second, third, 4th, and the 5th floors without obtaining any sanction. Paragraph. It has been submitted that the unauthorized portions are required to be demolished immediately, as they are what you submitted, they are extremely
In
the
dangerous condition, my lord, and that has been occupied.
structures are in a dangerous
We have to
condition.
have a structural stability certificate to show that it is stable. My lord, kindly, my lord, this I am disputing. My lord, from the bar, these things are being alluded to create prejudice.
Paragraph.
They are not giving me a copy of the order, they are giving
Yes.
prejudice.
It appears from the submissions made on behalf of both the parties that
There are 23 families who are deciding their tenants, my lord. I can't challenge the order of demolition. The
That-
assistant engineer's notice becomes sacrosanct now.
it appears from the submissions made on behalf of both the parties that the communication made by the assistant engineer on 29th of March 2022 is the order of demolition that has been passed. Stop. The same was passed more than 1 year back. Stop. The persons responsible did not take any steps pursuant to the order of self-demolition. Stop. After the police has been requisitioned by the Howrah Municipal Corporation to provide protection at the time of effecting the demolition of the unauthorized portions, unauthorized floors, the present writ petition has been filed. Stop. The learned advocate for the petitioner contends that the floors in question have been occupied by tenants. Stop. Next.
They are within permissible
The-
area, my lord. It's completely permissible.
It has further been contended that the
And all this
construction
was
has
raised
been
and they considered it. They ought to have made an order.
made on the made within the permissible limits.
Without sanction and permissible limits.
The court is of the opinion that till the authority sanctions and grants permission for raising construction, making consideration allegedly on the plea that the same is within the permissible limits, will not in any manner regularize or act as a sanction for the construction made. Stop. Any construction that has been made without obtaining sanction from the competent authority has to be treated as an unauthorized construction. Stop. Next. The petitioner was afforded an opportunity of hearing long back, the order of demolition has been passed more than a year back. Stop. The petitioner never took any steps to challenge the same. Stop. By this time, the order of demolition has attained finality and the corporation is liable to execute the same in accordance with law.
Right.
Stop. Next. The corporation has already sought assistance of the police for effecting the demolition. Stop. It will be open for the corporation to proceed with the demolition work in accordance with law. The
Grateful,
writ petition does not call for any interference. The writ petition fails and is hereby dismissed. Affidavit of service taken on record.
Not only one prayer, my lord, I had. An additional point, my lord, I wanted to raise, my lord, was that the assistant engineer had no jurisdiction. That has been raised in the writ. Would your lordship, my lord, kindly take down, my lord?
That has been determined, no, or decided in the order of this honorable court and confirmed in the division bench.
Grateful to your lordship.
Deviation.
আগের দিন দিয়ে দিচ্ছি আর affidavits are complete. My learned friend, corporation, they gave report in the form of an affidavit. I also gave exception in the report. Let me recollect my submission.
The only difficulty on our part, my lord, that the opposition we have used, and I find he has also used the reply. Possibly it has been given to my learned junior who is not coming to the court for.
Yes, I can see Mr. Day on the virtual mode.
I could not go through my reply. Therefore, I was just inquiring to my learned friend whether he has given reply or not. That is the reason why there may be some difficulty because he might have some points in response to my.
File the reply.
Yes, yes.
It is there.
On 2nd of May.
Exception.
Is there an exception to the report, my lord?
Yes, yes. Then
Yes.
it is to be adjourned. Is your client getting the pensionary?
No, no,
benefits?
it has been initiated after he lost his order, my lord, but not yet,
Not yet
yet
received.
to receive, my lord.
Then we will wait for some time. Let something flow. Thereafter, we will hear it.
Or
My lord remembers the matters. My lord remembers the matter.
crux of the matter involved with whether dias non, my lord, without any suspension order, without any subsidy order. This is our only point to be
Please come.
decided.
The affidavits in the matter are over. Claim is required to be heard. Shall I release it? You get it heard before any other bench. That will be better because this bench is hard pressed for time.
But you lost his only, my lord, give it directions, my lord, let them release the pension, my lord, immediately.
That is already there.
On the existing situation, of course, my lord, it has been said that it is in process.
First
The
of
other
February's
legal
order.
benefits have been delayed.
Highly see your losses, first of February's order, my lord.
It appears that the pension is yet to be released in
No.
favor of the petitioner. Stop. The corporation has taken steps to release the same. Stop. The corporation is directed to ensure that the admissible amount is credited to the bank account of the petitioner at the earliest. Stop. Learned advocate for the petitioner is granted leave to mention this matter for hearing before any other appropriate bench having determination.
But only one thing, my lord, let it remain in the list. But let it remain after a month, my lord. I don't have an order. Let it remain in the list, my lord. Otherwise, my lord,
I have
it
given
will
you
be very difficult, very difficult for me to enlist the matter, my lord. Let it remain in the list.
understand
In
your
the monthly list of August, my lord, let it be. Let it remain.
mention at that point that we will see. But
Let
as
it-
of now, I am
let-
hard pressed.
Let the matter remain in the list, my lord. Only for hearing, my lord. For kindly, my lord.
Giving you liberty to mention.
Otherwise, my lord,
Let us see what
my
can
lord,
be
at a
done.
hard
in
extent,
this matter.
my lord, hard the extension matter. Kindly do not release this matter, my lord. Only this my.
I am not releasing. I am giving you liberty to mention before any bench
Otherwise,
having determination. It may be this bench also. I don't say anything.
Let it remain in the list, my lord. Kindly list it in the monthly list
My
of.
list is becoming so bulky. I
No,
cannot.
no, my lord,
handle it.
only my lord. Otherwise, my lord.
Yes, nothing will happen. Call the next matter, please.
My lord, my appearance may be recorded. My appearance may be recorded. My lord, my appearance may be recorded. Item.
Oh, certainly. Record the appearance of Mr. De online KMC Orijit De.
Obliged, my lord.
তিনজন দিয়েছে অরিজিৎ দের নাম আছে আছে ঠিক আছে your name is already there. Yes.
Lord, I beg to appear on behalf of the petitioner, my lord. Lord, on the
Copy of the demolition sketch be circulated in advance. Has it been done?
yes, my lord, that was being done.
Yes.
Lord, it's such a, my lord,
Before my learned friend, my lord, starts submission, may I make one submission?
Lord, may I just place, my lord, my submission with regard to, my lord, the sketch plan itself. It has a checkered history, my lord. Page,
If the demolition sketch is already there, what more do you require now?
just, Lord, may I, Lord,
My lord, it has
let
been
my
decided
learned,
already.
Let me
let
see.
my learned friend just
It has
hand
been
over to you.
decided. Your lordship will kindly see the order
Yes, yes,
passed by
everything
the-
is being passed, my lord, by the KMC, my lord. I have compelled, my lord, to use the term favorism. Why, my lord? I will substantiate that.
Plagiarism.
But kindly, but page 60 of my lord's brief, where the previous writ petition was being filed,
Yes.
the Kolkata Municipal Corporation has filed a comprehensive report stating that there is no illegal construction. The construction is as per sanctioned building plan.
Page 60.
Page 60, my lord, this was the
No
report
unauthorized
submitted.
construction
Yes.
found, 2021.
In
Yes.
spite of that, this honorable court directed to inspect and submit a report and thereafter to proceed. Pursuant to that direction, ultimately, they have found, yes, some unauthorized construction is there. This is the second round of litigation. Since thereafter nothing was being done, but I filed this writ petition. But thereafter, successive order was being passed to hand over the sketch map specifying what is the actual area beyond the
Are you
sanction.
the person responsible for making us? Are
I am the
you,
complainant.
you are the complainant?
Yes.
All right.
But thereafter, your lordship directed them to specify what is the actual area deviated not from the sanction plan. Now,
Yes.
your lordship kindly compare page 39. That is the sanction building plan 39. Sorry, 94.
Aren't the private respondents appearing?
Yes, my lord. There was there, my lord, if I am not wrong.
They appeared, my lord, we could not serve the, my lord, the sketch map because of non-availability. My junior, my lord, tried.
Why? Nowadays, difficulty is the wakalatnamas are not here. So you don't know where the person sits.
And the problem is, my lord, neither the phone number nor the address is
Very well, my lord. I can place only one thing, my lord, from your lordship. Kindly takes up, my lord, page 94. The sanction building plan is being annexed.
94.
90.
Yes.
Kindly, my lord, remove that, my lord, so that.
Yes.
But kindly consider it, compare it with the, my lord, sketch plan. My lord, the sketch plan is before your lordship. At the top, they have mentioned the ground floor. Two anomalies, my lord, apparent I will show before your lordship. Nothing else. My lord, the top of the, my lord, plan, your lordship will get the ground floor sanction area is being mentioned 89.998 square meter. Has your lordship got it, my lord? That is the same column. Kindly compare it to the sanction building plan. My lord, the sanction building plan, right hand side, the portion, my lord, abstract area statement. Has your lordship got it, my lord? The sanction building plan. So they are saying the sanction area of the ground floor is 89.998 square meter. The right hand column, the abstract area statement, the third column of that proposed ground floor built up area. Has your lordship got it?
Yes.
That is 55.779 square meter.
Yes.
Apparently, my lord, they are doing this favorism to the private respondent when, my lord, in the sanction building plan, the sanction area.
For a moment.
1 minute.
For a moment, my lord.
Yes, yes.
Sanction area is being specified as 55.779 square meter. How, my lord, they can come with 89.998? Second anomaly I shall show before your lordship. That will appear
But then are you aware as to whether there has been any revision of the plan?
No. That is not their case. Nowhere. This is the only sanction plan. But it's apparent. Initially, they said no illegal construction. Now, repeated direction by your lordship, ultimately they have come up with this hand sketch map, this sketch, how it is apparently, my lord, beyond record. But I shall show. First, my lord, anomaly I have shown before your lordship.
Same in the first floor level also?
Yes,
First,
has to be,
second,
my lord.
third?
The sanction area will be
55,779 and this is 89. Second and third. Yes.
Now, my lord, kindly takes up the left-hand side column of the sanction building plan.
Yes.
Northwest elevation. The extreme left, my lord.
Northwest elevation.
Your lordship has got, my lord, the 3 feet wide draining line.
Yes.
Just after that, the entire area is 14584 square millimeter. That will come to 47 feet 10 inches. That has been written over there. That is exactly their boundary declaration also. This is, my lord, their registered boundary declaration. Your lordship compare it exactly same.
Very well.
Kindly now comes to the, my lord, the sketch plan. What is the area is being given? My lord, just the drainage line. Your lordship got the extreme left hand drainage line.
0.915 meter.
No, that is the drainage line. Thereafter, 15395 millimeter which was there in the sanction plan 14584, and now it becomes 15395, and the difference.
Where is that portion? Please show.
Kindly,
15395.
Yes. Has your lordship got it? Now it has been increased. Lord, I will show before your lordship if 15395 millimeter equivalent to 50 feet and 6 inches. And in the original sanction plan, it is 47 feet and 10 inches. Apparently, my lord, they are doing this favorism. Kindly appoint someone, my lord, from your lordship's courts panel. My lord, my client will bear the responsibility, every cost. The municipality is doing this consciously. And the entire elevation, my lord, in this sketch plan has been given to the southern side when the entire, my lord, this unauthorized construction deviation of sanction is on the northern side, which is just, my lord, adjacent to my client's property. They have enlarged the plot and entire, my lord, illegal construction has been shown to the southern side. When the entire, my lord, this elevation is being made in a, my lord, free space, my lord, which is open to the sky in a northern side. This has been shown to a southern side. I have consulted, my lord, with my client, and along with me, I have consulted one LBS after, my lord, this sanctioned building plan along with this sketch plan. Everything is, my lord, doing for the purpose of safeguarding, my lord, the interest of the private respondent. At least, my lord, their officer knows that how much sanction area is there in the sanction building plan.
Did the corporation issue any other revised building plan?
My lord. Unauthorized portion has been regularized, my lord. My lord will kindly see the order I have handed over. I have handed over, my lord.
During pendency of this writ petition,
Yes. Because the special officer building was there, he was insisting of the matter.
without giving us any notice, my learned friend is about, on the last occasion, as per your lordship direction, is about to hand over the sketch plan for the purpose of carrying out the demolition. They have carried out,
Participated in the hearing. It was
It's
your client.
absolutely
My lord,
wrong
who is
statement.
supposed to know.
It's
Very unfortunate that every time you, whatever you will be saying, that would be the gospel truth.
I have never said that, sir.
It appears so.
Which document are you referring to?
My lord will kindly come to third page, my lord, of the document handed over to my lord.
Which third page in the demolition order?
Yeah, demolition order.
But this was not been
Demolition
served
order,
to
the
us.
Third page.
This document is not,
Give a
only
copy
this
to
sketch
him.
plan is being served.
Please
This
give a
has not
copy
been
of
served.
this demolition order to him.
Kindly come to third page.
Yes. 29th of May.
29th of. These are the terms of regulation, in terms of regulation, such and such, the order of special officer, the demolition proceedings, such and such, the agenda note is given up for consideration. That the following order of SOB for the following things. Premises number has been given. Demand of fees and charges in compliance of order of SOB. The order of SOB has to be complied in terms of order number 13,2000 of rate.
Where is the order of the SO building?
For the first page.
What is mentioned over there?
Yes, my lord.
What is mentioned?
My lord, you will can see from the bottom of first page, my lord will read. The building plan has been sanctioned with advantage of Rule 142. Or a plot of area of 108.695 square meter. Shape of the plot differs from the sanction plan boundary declaration is submitted. As reported by department, covered area is increased from sanction plan, but the land area is more or less totally with boundary declaration and sanction plan. Complaint raised objection for encroachment of land, but failed to submit justified documents. Plan has been sanctioned with advantage of Rule 142. Undertaking is submitted for change of area of tenant increased. Back open space and side open spaces are deviated and decreased from sanction plan. Area of under section is 19.688 square meter. Structural stability certificate is submitted by Shuddhashil Bhomik LBS such and such. Considering the small plot of land, I am inclined to pass order to retain the structure with the deviation on payment of fees under section 400 30 days from the date of complication of order, failing which action is taken by the department. These states plan,
what prevented the corporation authority to submit before your lordship that yes, already they have regularized.
was there before the SO. Plain and simple thing I submitted.
Prior
I
to
do
my lord,
not know, my lord.
prior
Learned
to,
friend is my lord trying to my lord call out butter from the water.
I'm not trying to call out anything, my lord.
Yes.
I'm submitting something which is on record.
Nothing prompted. Nothing prompted us because it was the instruction was not with us. I'm a counsel.
Initial instruction was absolutely wrong. Thereafter, they found, yes, there was a demo.
Please come. Copy of the order passed by the special officer within bracket building KMC in demolition case number 28.
My lord, kindly once, my lord, your lordship records that in respect to this demolition case number, no hearing was being provided to me. Prior to
Slash
issuing this order.
1V slash 22-23 along with the demolition sketch has been handed over in court. Stop. Copy of the same has also been handed over to the learned advocate representing the writ petitioner. Stop. Along with the aforesaid documents, the money receipt showing payment of rupees 1,14,088 only by the private respondents before the Kolkata Municipal Corporation on account of regularization of the unauthorized construction on 24th of January 2023. It's very strange. Order passed by the SO building in March. And the payment is made in January.
Possibly the year would be different kind of. Possibly
Year
I
will
do not
be
know.
different.
No, year,
It's
my
in
lord.
March 2023
Yes.
and payment in January 2023. How is it
Absolutely right.
possible?
Let me check. My lord, it was a security deposit. My lord is perusing the last page.
Last page.
Last page is security deposit.
At the bottom, see, at the bottom, charges
Mountain
for
roads.
regularization of the unauthorized construction.
Yes. And what is the security, my lord? I do not know whether there is a provision for keeping security deposit.
There is a provision for keeping security deposits.
Oh, but I am told there is a new circular. So I am not here.
Yes,
That the payment has to be,
deposit, it has to
yes,
be
it
made.
has to be paid earlier.
তাহলে ওটা লিখে দিন। কি বললাম?
My lord, at fourth page, my lord.
On account of regularization charges hyphen security deposit. ঠিক আছে? Has been has been produced 24th January 2023 has been produced in court. Stop. Next.
In
But
fourth
one
page,
is, my lord, 16th of May 2023, my lord, will, receipt is there, my lord, will find. 16th May 2023, another receipt is there at fourth page.
17th June, nothing.
Fourth page.
Fourth page for 17th June, nothing. দেখুন ডেটটা তো 17th June.
15 June 2023.
That is amounting to 3,58,242.
Yes, that is the regularization charge. Another was the other
Oh.
1 lakh is security deposit.
Stop. A further receipt issued by the Kolkata Municipal Corporation on 17th June 2023 showing payment of rupees 3,58,242 on account of charges for regularization of the unauthorized construction has also been annexed with the documents handed over by the learned advocate representing the corporation. Stop. Next paragraph. The learned advocate for the petitioner submits that the corporation did not afford any opportunity of hearing to the complainant prior to passing the order of regularization. Stop. Next. The order passed by the special officer building. Building is within brackets. Special officer building is an appealable one. Stop. It will be open for the writ petitioner to challenge the same before the appropriate forum.
Kindly give me some time so
In
that I
accordance
may not
with
file
law.
under section 5. Today is the date of knowledge.
If so advised. Stop. Next. But you can take all these points, Mr. Mukherjee, you
Yes,
can
madam.
take all these points in the section 5 application that you are not given opportunity of hearing. This I have recorded, that no order was also served upon you.
That I can, that will take some more time, that's why.
Doesn't matter. He has already spent more than 4 lakh,
Yes,
5
that
lakh
I've
of
seen.
rupees.
That I've seen.
To some extent, your client will be relieved that payment has to be made. Writ petition stands disposed of.
Great.
The moment your enemy pays something,
Yes, yes.
mental satisfaction is there.
Great.
My lord, I am for the petition.
Yes, please.
For the respondent Panchayat Samiti, my lord, on last occasion, your lordship, my lord, they could a report.
Did you give a copy? Any exception filed?
No, no.
There is no direction.
Lord, I am raising question. Who has kindly see who has affirmed this affidavit?
In your exception, raise this question.
Sir, it is challenging a tender process, my lord, this ending today, tomorrow, my lord.
Tender process is?
My lord, you will recall, my lord, they have challenged a tender process, my lord, initiated by, my lord, the Sonamukhi Panchayat Samiti for leasing of Ferryghat, my lord. The petitioner before your lordship is, my lord, a defaulter who has not paid the rent for a long time. Tender condition provide, my lord, where, my lord, there is used pending against the, my lord, the Panchayat Samiti, they are ineligible to participate. Petitioner in the earlier round of litigation, my lord, they said we want to participate.
No, tomorrow is the date of tender.
It will be over, my lord. It's continuing. Today is the last date of, my lord, the public submission of considering bid. They have not submitted bid. They have not participated in the tender down. They are challenging it. It's continuing since
You do not intend to participate.
No, I have challenged the tender notice on the ground of jurisdiction.
Very well.
On
Please
the
come.
ground of jurisdiction.
Prejudice, my lord,
And
because
tender was not held, my lord. So far, my instruction is that
Report in the form of
the election period.
Lordship,
filed by the respondent numbers 3 and 4.
Lordship, Ms. Manali Ali appearing in this matter on behalf of the state, as he could not come to the court due to some urgency. So praying for not today. So
What will happen to the tender that will be open tomorrow?
Lordship, I am not instruction Manali Ali. Please don't-
Very well. Respondent numbers 3 and 4. Okay. The petitioner seeks leave to file an exception to the same. Stop. Let exception be filed by a fortnight. Stop. Learned advocate for the Panchayat Samiti submits upon instruction that tomorrow is the date for opening of the bids.
It has been opened, my lord. My lord will kindly see, my lord. the
For,
notification.
for tomorrow is the date
My lord,
for,
it is closing end of auction, my lord.
what does end of auction mean?
My lord will see, my lord. There are initially, my lord, the EMD has to be submitted, my lord. There, my lord, thereafter, my lord, the other bids and the initiate has yesterday commenced today, my lord. Tomorrow it will be closed.
Date of auction, not
It is, my lord, a NIC tender, my lord. If the date goes, my lord, we cannot reopen it again.
Oh,
Date of
all
auction.
the bids have been put in. Tomorrow is the date for opening the bids.
No, tomorrow is the date of auction.
My lord will
Oh,
kindly.
Tomorrow is the date of auction.
show me the NIT.
Yes.
Kindly come
My lord
to
will kindly see, my lord.
page 7,
Of the writ petition,
page 29. Page
29 of
29.
the writ petition.
Yes.
Is the 32, my lord. It starts at. Today, my lord, it's 23rd auction start date. Initially, my lord, date of participating.
Kindly see the serial number 5,
Good.
page,
Acha.
page 32.
Acha, tomorrow is the,
Close date.
it's the auction end date. Stop. Next paragraph. The petitioner has raised an issue with regard to the jurisdiction of the executive officer of the Panchayat Samiti to float the notice inviting e-auction. Stop. Next. As it appears that the petitioner has not participated in the auction process. Accordingly, the the petitioner will not be affected by any steps that is being taken in the auction process.
Because now, my lord, petitioner is the
Next.
existing operator of the said ferry guard.
The petitioner happens to be the existing operator of the ferry ghat.
Is that expired?
No, that is not.
The lease of the petitioner has expired
That is why, my lord.
by efflux of time. Next. Any steps taken during pendency of the writ petition shall abide by the result of the same.
Matter will appear in the.
The matter will appear in the list on 1st of August.
As per orders, my lord.
Yes, for orders.
12, 13, same.
12th is also the same.
My lord, may I file that?
Right. Thirteen is also the same. 13 also same.
Lordship, extension of interim order.
Who is your other side?
My lord, they have filed their affidavit in opposition there, my lord, some time back, my lord.
Chandanagar, that means Mr.
Yes.
Suman Basu will be there.
Lordship was kind enough on the last occasion, they didn't even absent. Lordship was kind enough
What
to,
are you giving?
my lord, affidavit in opposition. They have served us our reply. This is our reply, my lord. You have circulated it.
Ashwin.
My
What
lord,
is the
service
interim order that you are enjoying?
30th June.
What is the interim
My
order?
lord, they have certainly blacklisted myself without providing any opportunity of hearing, as a result of which that.
Acha. The matter is appearing under the heading extension of interim order. Stop. None appears on behalf of the Chandanagar Municipal Corporation. Stop. Learned advocate representing the petitioner submits that a copy of the affidavit in opposition was forwarded, and accordingly, the petitioner files the affidavit in reply. Stop. The original affidavit in opposition is not filed in court. Stop. Next. The interim order that is pending in the matter is extended, not pending, that is subsisting in the matter, is extended till 30th of September 2023 or until further order, whichever is earlier. List on 4th of August 2023, marked for hearing.
My lord, the lordship was kind enough to direct us to effect service last occasion
Upon
upon the Chandanagar municipality. We have done it.
municipality.
Yes, sir.
And you have effected service.
Yes.
Municipality is a party.
Yes, ma'am.
And none represents Chandanagar municipality. Stop. If the notice.
Yes.
This is the notice, not the affidavit of service. Notice showing service upon the Chandanagar municipality be taken on record. Please call the 1 PM matters.
14886.
এসছে কিছু? একটাও আসেনি? লিস্ট করতে পাঠিয়েছেন? আচ্ছা, নাম ধরে ধরে ডাকুন। ফাইল এখানে আছে তো? ফাইল কি এখানে আছে? নাম ধরে ধরে ডাকুন, তাহলে পার্টিরা এখানে আছে বলতে পারবে। লিস্ট না হোক, লিস্ট করান আপনি তাড়াতাড়ি। 3 matters are there in the supplementary list. Marked 2 PM. I'll take it up at 2. There are others which have been filed today, supposed to be taken up at 1 o'clock. I'll take the 1 PM matters now. And have you received copies?
Yes, I have.
Very well.
14886
নাম ধরে ডাকছে।
नाम बताओ. Just tell me the name.
অমরেশ বেঞ্চ।
Have you sent the list for printing?
অমরেশ বেঞ্চ।
লিস্ট কি প্রিন্টিং এর জন্য পাঠিয়েছেন?
My lord, only one thing.
নিয়ে গেছে? লিস্ট হোক, আপনি নাম ধরে ডাকুন।
My lord, only one thing before your lordship starts, in the leave that in the morning your lordship granted leave, inadvertently it has been stated that leave is granted to file the memo of appeal. It should be corrected.
All matters.
All matters that has been given as
আপনি কি ডিভিশন বেঞ্চে আছেন? আপনি কি ডিভিশন বেঞ্চে আছেন? মেমো অফ অ্যাপিল কোথা থেকে এলো? আপনি দেখি, লেট মি সি ওয়ান কপি।
at least in my copy, my lord.
মেমো অফ অ্যাপিল কোথা থেকে হবে? তো রিট পিটিশন, মেমো অফ অ্যাপিল কোথা থেকে আসবে? এই সবগুলোকে কাটবেন, বুঝতে পেরেছেন? ফাইল দি রিট পিটিশন হবে, বোঝা গেল? ঠিক আছে, এটা প্রথম মামলা তো? এটা প্রথম মামলা? আচ্ছা, যেটা বার করেছেন সেটাই। চায়না মাঝি।
Yes, Madam, I'm for the petitioner.
Yes.
My lord, this petitioner belongs to scheduled caste community. My lord, in that particular constituency, before this, my lord, this year, it was only one constituency which has been divided in 2 parts. Now, my lord, it was for the scheduled caste. My lord, now one part has been given as the general caste and one part has been given as the scheduled caste. It has been. My lord, inadvertently in the general caste, my lord, I filed my nomination on 12th. My lord, when I came to know that it is general and it has been divided into 2 parts, my lord, I have, my lord, given my nomination form on 15th in the scheduled caste. And my lord, I have withdrawn my nomination in the general caste seat, which was my lord there. My lord, thereafter, my lord, it has been my lord, the nomination was not considered, and my lord, and from the final list, my name didn't came. My lord, no reason has been given as to why.
1 minute. Initially you filed it in a general caste seat. Thereafter you filed it in the scheduled caste seat,
Scheduled
the
caste seat.
reserved seat. So after you filed your nomination in the reserved caste seat, what happened?
My lord, thereafter, my lord, I have withdrawn the nomination in the general caste. So, my lord, only one nomination was there in the scheduled caste seat. My lord, thereafter, my lord, in this
Last date for filing the nomination was 15th.
yes, my lord, within 15th,
did you
15th, I have
file the
filed.
nomination in the reserved category seat?
Yes,
You have?
yes.
Was it scrutinized?
It was scrutinized. It was given in the in the list. My lord, kindly come to
Where is your scheduled caste candidate with caste certificate?
It is annexure
P1
P1,
at page.
page 25.
Page 25. China Marji. Yes.
In my lord,
Where
kindly
is
come
the
to
receipt showing your submission of nomination?
my lord, P2. My lord, it is page 28. Relevant is page 29. This is for the general. It, on 12.
Show me regarding the scheduled caste.
Scheduled caste. Page 31.
31. 31. This is
No,
on
sir,
12.
33.
15th of June 2023. China Marji 2 number block तारीख है. Yes.
Now, my lord, kindly come to page 35.
Yes.
After the scrutiny, my lord, in both the constituency, my name was there. My lord, kindly see
China Marji, China
China
Marji.
Marji and China Marji. Thereafter, my lord, I have withdrawn the general caste. My lord, that is at page 36.
36.
Page 36.
Yes.
Thereafter, the final list,
Page 39.
page 37 and 39. 37 is the general category. My lord, I have already withdrawn. 39 is the scheduled caste category. There, my lord, my name was not, my lord, considered.
Commission.
Yes, your lordship, in the synopsis itself, though I have heard substantial part from the petitioner, the petitioner, without knowing such fact, has inadvertently filed her nomination papers from.
No, that is over.
Yes, that is over. Your lordship, what is usually being submitted before the before your lordship is, one is the GEMS portal, which has just been shown to your lordship. This is whoever is submitting the nomination. It is just an acknowledgement, a sort of a receipt that, well, you are.
No, that receipt is also here.
Yes.
That it has been
yes.
filed. But why after scrutiny, the name of the petitioner is not appearing in the list? No idea.
No idea. Being served so late, I have to go to the concerned video again, ask, again come back.
Then let
And
the
moreover,
video.
your lordship, it is now, that is on the 23rd. They are before your lordship, stating that we have been, 20th, the list was published. 20th of June, the final list was published. And now on the 23rd, they are before your lordship, saying that this is wrong, that is wrong.
So it is only after publication that they got to know. Isn't it? 23rd, they have
I tell you, caste certificate to me originally submit kore
please come.
on the 46, in the 46.3.
The petitioner claims to be a scheduled caste candidate. Stop. She submitted her nomination for contesting the Panchayat election, 2023. Inadvertently from a general category seat on the 12th of June 2023 and also submitted a nomination against a reserved category seat on the 15th of June 2023. Stop. The petitioner withdrew her nomination from the general category seat on the 19th of June 2023. Paragraph. It appears that the last date for making nomination was 15th June, within which the petitioner filed her application, not application, nomination. In the scheduled caste nomination, in respect of the seat reserved for the scheduled castes, and on the 19th of June, she withdrew the nomination inadvertently made in respect of a general category seat. Stop. The last date for withdrawal of candidature was 20th of June 2023. Stop. Next. The final list of contesting candidates was published on 20th June 2023. As the name of the petitioner did not appear in the said list, the petitioner is aggrieved by the same and has filed the present writ petition. Stop. Next. Prayer has been made for permitting the petitioner to contest the election from the reserved category seat. Paragraph, learned advocate representing the State Election Commission is yet to receive any instruction in the matter. Stop. Next. Did you raise any objection before the concerned authority?
Well, I didn't get any chance because
Why?
well,
21,
after
22.
20, well, it was actually published on 21st. Then, my lord, we have
Not on 20th? 20th.
well, 20th. It is officially saying 20th, but it was actually published on 21st in the late night. Thereafter, my lord,
21st late night?
yes. My lord, it is website portal. It was not on 20th.
It was not?
It was not on 20th. 21st it
20th, it was not there.
no. My lord, maybe the date has been given on as 20th, but it was uploaded on 21st. So thereafter, my lord, I didn't get any chance, and my lord, I straightway come.
Achha. Learned advocate for the petitioner submits that
You were
though
present during scrutiny?
though the final list of contesting candidates submits that the final list of contesting candidates was uploaded in the official portal of the commission only on the late night of 21st of June 2023. Stop. The petitioner did not have any opportunity to raise any objection before the concerned returning officer. Stop. Next. In view of the above, the leave is granted to the petitioner to raise appropriate objection before the concerned returning officer. Stop. If the objection is filed by today, the same shall be considered by the concerned panchayat returning officer at the earliest, but positively by today is 23rd, 25th
Let
of
me I say
June.
one thing only. Another client is present in court now.
Yes.
She has to go back to the place, and thereafter, my lord,
Yes.
so like
Where is the place? In
it
Hubli?
is Khanagul. It is already. It will take 3 hours at least. My lord, the officer will go.
আচ্ছা তাহলে করে দিন টুডে যেখানে বললাম by 10 o'clock tomorrow.
Lordship, Saturday and Sunday are there. 26th will be a better date.
No, but they are working overnight. Your officers are working overnight. Why will you keep them?
But your lordship, I'm confident on Sundays hardly there will be anybody. Tomorrow
Let them go.
I would propose.
What is the official hours? 10 o'clock in the morning?
Yes, it starts from 10 and yes, 5:30. Though there are
No, but then official hour is 10.
Yes, yes.
So
But
by
usually it
12,
is.
by 12 o'clock, kalke, 24th of June. কি বললাম? না কবে অবজেকশনটা জমা দেবে? By না if the objection is filed by 12 noon on 24th of March 2023, the same shall be considered at the earliest but positively by 26th June 2023.
Lordship
This
is saying
petition-
March.
Acha,
Lordship is saying 25th of March.
June. Acha. Our if the panchayat returning officer accepts the contention of the petitioner, then she shall be permitted to contest the election. Writ petition disposed.
My lord, If not, my lord, a reason order to be passed so that I can come back.
In the event the petitioner's prayer is not accepted, then a reasoned order shall be passed and communicated to the petitioner immediately. Yes, call the
My lord,
list.
may I get a plain copy of this order?
No,
To act on the server copy.
act number item.
Server copy.
My lord, act on the server copy. Act on the server copy.
Is anybody not acting?
Yes,
Let
my
me
lord,
know if somebody is not acting.
Yes, there are.
We'll see what is to be done.
My lord, I beg to appear for the petition.
Roshan Ara
Roshan Ara.
Begum.
My lord.
Where is it?
Supplementary is published, I guess. I guess. My lord, this person, my lord, this lady had submitted a nomination as an Indian National Congress candidate. Her form was accepted. Scrutiny, it was okay. Her form B was also accepted, meaning thereby, my lord, scrutiny was done on 17th, it was okay. On 19th, she submitted a symbol that is allotted by the recognized political party. That was also accepted. Now, my lord, there was a list published in the BDO office notice board. From there also my name is appearing. My lord, that would appear at page number 17 of the writ petition. Subsequently, till 21st, my name was there in the website. Subsequently, after 21st, my name is not there in the website and I couldn't find my name.
You cannot find.
I
your
cannot find
name.
my name. Now, my lord, I pose this question, scrutiny, okay. Had there been a problem in this scrutiny, form B would not have been accepted. That is the allotment of symbol. It was accepted and there is a receipt also from the office of the BDO.
Let me hear. Commission.
Lordship, I just have to say that the dates are over, lists are published.
Same thing. I can see an order has been annexed at page 23.
My lord, it is that BDO, my lord, wherein your lordship had directed for a CBI investigation.
What happened to the appeal?
But again, the state.
Yes,
Just
yes.
now, stay high. Oh, stay highly, stay highly, stay highly. Stay high, step नहीं दबाना. My lord would kindly comes at page 18 once.
But why have you annexed page 23? This is regarding the tampering. It is not.
No, I just wanted to, my lord, bring it to the notice. It is that concerning, my lord, wherein the discrepancies took place.
Yes, you want to say that.
Yes, you could have mentioned it. It's all right. But then similar orders were passed. Where are those orders? Did you get any? Please come.
My lord would kindly see there was a
Dismissal. But they were allowed also. Some
Yes.
petitions were allowed
Yes.
also. I do not have the list. I do not have the order. I do not have the file. You have to produce before the court. The petitioner.
Hey, affidavit of service. Affidavit of service.
The petitioner participated in the filed a nomination for participating in the.
And my lord, my another submission is that my lord, after publication of my lord complete. No,
Let the election commission take a stand. How is the state concerned about it? How the state is concerned?
I have already I have already made that submission.
As a participating and contesting the Panchayat General Election 2023. Stop. Her nomination papers were scrutinized and being found in order, her name was published in the list of candidates in the office of the Block Development Officer, acting as the Panchayat Returning Officer. Stop. Next. The grievance of the petitioner is that all on a sudden, her name has been dropped from the list of selected candidates. Stop. No reason whatsoever has been disclosed to the petitioner as to why her name was suddenly dropped. Stop. Next. The petitioner asserts that she did not withdraw her nomination. Stop. Next. prayer has been made to allow the petitioner to contest the election as a candidate of the Indian National Congress. Stop. Next. Did you raise any objection?
Yes. My lord would find my representations would at from page number 19 onwards
19 onwards.
to the district panchayat election officer and to the assistant panchayat returning officer. Both has been made.
Paragraph, learned advocate representing the respondents opposes the prayer of the petitioner. It has been submitted that as the final list has been published, accordingly at this stage, the prayer of the petitioner cannot be accepted by the court. Stop. Next. The only remedy is to file an election petition. Stop. Next. I have heard the submissions made on behalf of all the parties. It appears that the petitioner's name was published in the list of selected candidates by the office of the Panchayat returning officer after the process of scrutiny and withdrawal of nominations were over. Stop. Thereafter, as the petitioner did not withdraw her nomination, accordingly, there was no occasion on the part of the Panchayat returning officer to remove the name of the petitioner from the list. Stop. Next. An objection to that effect is pending consideration before the district Panchayat election officer. Stop. The instant writ petition is accordingly disposed of by directing the district Panchayat election officer to take a decision on the objection filed by the petitioner at the earliest, but positively by 26th of June 2023. Stop. In the event the candidature of the petitioner is found to be correct, comma, then not correct, to be in order, comma, then she shall be permitted to contest the election. Stop. A reasoned order shall be passed in the event there is any error in the nomination filed by the petitioner, and the same shall be communicated to the petitioner immediately. Writ petition disposed. Next one is Amoresh Bej and others.
Petitioner, my lord. Here, my lord, the petitioners are contractual employees. Your lordship knows, my lord, after the order passed by the division bench, specifically division bench said contractual employees can be deployed as a last resort, and if it is deployed, it should not be above the fourth polling officer. I can place the judgment, ma. I have been
Deployed for what purpose?
election duty.
Election duty.
It has been for your lordship's convenience. Your lordship can have the specific mark paragraph 66.
In this, your lordship, I will be needing specific instructions.
My lord, only thing, my lord,
Let me hear once.
Yes.
I have been asked to undergo training for first polling officer and presiding officer. This cannot be, my lord. Paragraph 66, if your lordship sees of the judgment.
The petitioners are contractual employees.
Yes, my lord. The relevant, I have annexed my appointment letter also, my
Whole-time
lord.
teachers, contractual whole-time teachers.
My lord, petition number 1 and 3 are contractual whole-time teacher, and petition number 2 is a contractual lecturer in a polytechnic college.
Achha, lecturer in a polytechnic college. Yes, the division benches order.
Paragraph 66, my lord, I have
Contract.
given that to your lordship.
Yes, they will be deployed as a last resort. Both polling officer may be transferred.
Next, cannot be a
Lower than the assigned to the fourth polling officer. Show me the duty that you have been assigned.
My lord, it is at page 27.
Duty.
Amoresh Bej, number 1.
Page 27, my lord. My name, Amoresh Bej. Appointed as, my lord, first polling officer. My lord, thereafter, next page, my lord. Shantanu Pramanik, my lord, appointed as first polling officer. And page 29, my lord, Rajesh Mujumdar, appointed as presiding officer.
Yes.
Instructions.
It is still contractual. It is still contractual. My lord, I will be the happiest person. We are not regular teacher, my lord. The point remains, we are not regular teacher. No, no.
Please come. Did you raise any objection? Has
My
any
lord,
objection been
petitioner
raised?
number 1 and 3 has raised objection. My lord, only thing, my lord, petitioner number 1, tomorrow is the date fixed for reporting or training. But yes, suddenly, if what is the purpose of conducting training if I cannot be appointed? Full-time teacher. My payment to full-time teacher.
The petitioner numbers 1.
No, my lord. No, my lord. It's not a matter of content, my lord. This order needs to be set aside. In contempt, it cannot go beyond this order.
Petitioner numbers 1 and 3 claims to be appointed as contractual whole-time teachers under the Government of West Bengal Education Directorate. And the petitioner number 2 is engaged as lecturer in an electrical engineering polytechnic college on contractual basis. Stop. Next. The petitioners have been appointed to now the petitioner number 1 and 2 have been appointed to perform the duty of the first polling officer, and the petitioner number 3 has been appointed as the presiding officer. Stop. According to the petitioners, the Honorable Division Bench of this court, in a public interest litigation, delivered judgment on 13th June 2023 in WPA within bracket P 250 of 2023 within bracket Sri Dipankar Reeth versus State of West Bengal and others, wherein the Honorable Court was pleased to direct that if contractual employees are to be deployed, they are to be deployed to undertake work lower than the work assigned to the 4th polling officer and not assigned any duties above the 4th polling officer. Stop. The petitioners, being contractual employees, submit that they ought not to have been appointed either as the first polling officer or the presiding officer. Stop. Objection has been raised by the petitioner number 1 and 3.
1 and 3.
1 and 3 with a prayer for withdrawal from election duty. Stop. The same is pending consideration. Stop. It appears that the petitioner number 2 is yet to file any objection. Stop. Next. The present writ petition is disposed of by directing the district panchayat election officer and the district magistrate, being the respondent number 5 herein, to take a decision on the representation filed by the petitioner numbers 1 and 3, seeking withdrawal from election duty in accordance with the direction passed by the Honorable Division Bench. Stop. The petitioner number 2 will be at leave to file representation before the aforesaid respondent by today. Stop. A decision shall be taken in the matter at the earliest, but positively by 26th June 2023. Stop. Next. The till such time the aforesaid respondent takes a decision in the matter, comma, the petitioners will not be required to attend any, what it is called, training. Any training as directed. Stop. Writ petition disposed.
The one thing I have made, since separate district magistrates are there, I have made respondents 5, 6, 7. It should be the without naming the respondents, my lord, because they.
Acha, thik ache. Don't give the respondent number. District, Panchayat, election officer and district magistrate. Respondent number ta deben. Disposed of. আগে পাঁচখানা এসছে নিয়ে নিন, লিস্ট হয়ে গেছে, আবার একটা লিস্ট হবে। এর বাইরে কি আর লিভ দেওয়া হয়েছিল? এখানে 10টা প্লাস 5টা এসছে, 10টা এখানে আছে প্লাস 5টা, আর লিভ দেওয়া হয়নি তো? 15 সবগুলো আজকে ডেকে দেবেন। আরেকটা লিস্ট ছাপান ইমিডিয়েটলি।
Madam, I am for the petitioner, my lord. Madam, the petitioner is an approved assistant teacher in Muthuranath High School in New Alipur, my lord. He has appointed in 1999. Madam, all along, madam, he has discharged his duty as a polling officer. Madam, this time, my lord, because he is having a aged mother, 88 years old, and only one son is having, my lord. He is a physical disabled. My lord, 19 years old. Madam, his presence
Where is your objection?
Madam,
Page 17, P3.
Madam, representation page 17, madam.
Ashun, please come.
क्या चाह रहा? What he wants.
The petitioner seeks exemption from election duty. Stop. He is serving as an assistant teacher of a high school. Stop. The petitioner has made out several grounds on which his prayer for exemption from election duty be considered. Stop. A representation is pending consideration at the end of the District Magistrate, South 24 Parganas. Stop. Without going into the merits of the said representation, comma, the instant writ petition is disposed of by directing the
Respondent 4, madam.
respondent number 4 to take a decision on the representation filed by the petitioner.
Madam, day after tomorrow is the reporting date.
Acha. A decision shall be taken in the matter at the earliest, but positively by 26th of June, 2023. Stop. The learned advocate for the petitioner is directed to forward a copy of the representation along with all documents in support of his prayer for exemption to the aforesaid respondent at the time of communicating the order of the court. The writ petition stand disposed of.
Madam.
Well, I'm for the petitioner. Madam.
छोटा-छोटा.
Yes.
And the petitioner with your lordships belongs to scheduled tribe community. Your lordships will get it at page 12. Now, my lord, this is in regard to the filing of nomination in regard to Mayureshwar 1 block. Now, my lord, it has initially 14 constituencies. From this year, 18 constituencies. Under the conception, initially I filed 14. My lord, that your lordships get it at page 16.
You filed 14 means?
14 constituents number. That was reserved for OBC.
Constituency number was wrongly put
No,
in the nomination.
only that was reserved for OBC. I belong to ST,
Yes,
so I cannot file it.
yes.
Now that was I filed in 9th June. Your losses will get it at page 16. 16 and 17. So, my lord, this was on 9th June. As soon as I came to know that this cannot be filed, my lord, on 15th, your losses will get it at page 18.
Page 17 was inadvertently filed from a scheduled caste reserved seat.
In OBC reserve seat, I
Oh,
filed
OBC reserved seat and you are a scheduled caste
ST,
candidate.
ST
Huh.
scheduled.
Then
Now, my lord, on 14, page 18, I filed in the reserve vacancy, my lord, constituency number 18. That your losses will get it from page 18 and 19.
yes,
Then your lordships, kindly, my lord, page 20, nomination paper was accepted by the signature of the assistant panchayat returning officer, all that.
yes,
It was scrutinized, page 21, your lordships.
yes.
At the bottom, now last two name, just above that, constituency number 18, your lordships is getting it probably little illegible. Constituency number 18. And immediately thereafter, my name, Fulmoni Mardi. So my list in the list, my name was published. It was in the website. And your losses will kindly see the next page. In the middle portion, constituency number 14. My name was not there. Therefore, that was rejected because automatically that was rejected. Now on 21st, the day for submission of the symbol, I went there. I was orally informed that my list candidature have been cancelled without informing any reason. I immediately lodged a complaint at page 23 on the 19th. Now, today I am before your losses. My lord, kindly do not direct them to dispose of this representation. Kindly let them come up with my lord, reasons before your losses.
Then none of the matters can be disposed of and the parties will never get any relief.
No, I tell you,
Because
your lordship,
every day new matters are coming up.
and in a
If I
situation,
keep this matter pending,
I tell your losses because I made it 19th. I'm
Yes.
before your losses in 23rd.
yes,
Election in 18th. Suppose your losses on 20, my lord, after 26 they reject it. What might do?
no, no, I'm fixing up a time within which it is to be done.
But any date your losses, my lord, not before Monday or some that. Then again I have to come up. So let them come up with a reason. That was the reason.
No, nothing. Please come.
Then again I have to come up before your losses.
I can't help.
Because I submitted at the right time. This was
Tell
accepted.
me one thing. Why are so many candidates so very interested to participate in these elections? Is it for providing service to the citizens? I do not think. It is for some other reason.
This was service to this city.
Service to the nation.
Has to be done.
It has to be. That
has
is
to
the ideal situation.
That's ideal situation.
And is it so? Are the
Or-
citizens very happy with the services that are being rendered?
No, that
It
my lord,
seems it is for their self-service that these
That-
number of nominations are coming up.
number of
for
nominations,
self-service, not for the service of the nation.
76,000 seats. 76,000 throughout the state. So it had to
So
be, my lord.
more the number of seats, the better service the
That's the
citizen
your
should
losses
get.
has to consider the ideal situation unless your losses comes up with
The,
specific case.
the petitioner claims to be a member of the scheduled caste community.
Scheduled tribe, my lord.
Scheduled tribe community. Stop. She inadvertently filed her nomination in respect of a seat which was reserved for the OBC. Stop. On detection of the error, she immediately filed another nomination in respect of the seat reserved for the scheduled tribe. Stop. The nomination was filed within the prescribed time limit. Stop. Next. The nomination of the petitioner was scrutinized and a list was published in respect of the constituency reserved for the scheduled tribe wherein the name of the petitioner appeared. Stop. Paragraph, grievance of the petitioner is that. Now, the petitioner withdrew her nomination in respect of the seat reserved for the OBC candidate. Stop. Next. The grievance of the petitioner is that in the final list that was published, her name did not appear.
The only one thing, physically I did not withdraw, it would automatically cancel that OBC.
আচ্ছা,
That
তাহলে
wrong
ওটা
factor
হবে
losses should not.
withdraw যেখানে বললাম না, the nomination filed by the petitioner in respect of the seat reserved for the OBC candidate stood cancelled automatically. আচ্ছা, কি বললাম last time? Her name was not published, did not appear. Stop. The petitioner filed an objection before the block development officer. Which block?
This was Mayuresh, I have filed the objection before the SDO, my lord. Your losses will get it at page
SDO BDO
24.
both.
20, BDO 23.
Yes. So the block development officer, Mayureshwar Development Block.
We to returning officer.
On the 19th of June 2023, stop. Allegation is that the same has not been disposed of till date. Stop. Next. Without the petitioner asserts that she did not withdraw her nomination from the scheduled tribe reserved seat. Stop. The petitioner has not been intimated any reason as to why her name has been dropped from the final list of eligible candidates. Stop. Next. Paragraph. As it appears that the objection filed by the petitioner is pending consideration at the end of the block development officer. Accordingly, the instant writ petition is disposed of by directing the Panchayat election returning officer and the block development officer Mayureshwar 1 to consider the said objection and to pass a reasoned order and communicate the same to the petitioner. Stop. In the event it appears that the petitioner will be eligible for contesting the election, then the said respondent shall permit the petitioner to contest the election. Stop. A decision shall be taken in the matter at the earliest, but positively by 26th June 2023. Stop. Next. Learned advocate for the petitioner is directed to forward a copy of the objection along with other necessary documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
This is my. Well, at the nomination paper which has been uploaded in the site of the commission, I find one of the candidates who is contesting in a Panchayat Samiti. Well, at page 10, he has to describe what are the criminal cases against him. There are still criminal cases against him. He did not disclose it. Now his nomination has to be signed by a proposer. Page 12. Shakhider Shakur ঠিকানা. The address has been given, no signature. In spite of that, this nomination has been
accepted
to be valid. I have made a complaint before the authority. And a series of complaints. Page 15 is the before the returning officer, 16 before the governor, and 17, 18 is before the commissioner. 20 is the to the company.
Page 10, it is mentioned ache.
But he has to disclose which are the criminal cases, what is the number, what is the section, because after this declaration, he has to declare before in the auspicious places with his photograph. I am accused of these cases.
At the time of filing these nominations, the papers are also required to be given. Isn't it? It is mentioned ache, but the details are not there. Miss Sinha.
That's, I'm little confused. He says private.
The details of the criminal
Yes,
cases are not
is
there.
Not there.
Disclosed.
Nothing is there. In the synopsis also, he writes that in page number 3 of his nomination paper, the address and whereabout of the witnesses he did not mention. The
Yes.
name of witness-
Private respondent.
Nothing is there.
Private respondent is a party.
Yes, where is he? Where is he?
Please come.
Maybe he's a candidate. You come here before the court and you ask for cancellation of his nomination. And he's not.
Come against the inaction on part of the respondent authority.
Well, then there will.
Who is required.
Let there be a consideration
something.
order, your lordship.
The petitioner is aggrieved by the inaction on the part of the Panchayat returning officer to take consequential steps in response to the complaint lodged by the petitioner for cancellation of nomination of one Shah Alam Sarkar being the respondent number 4 in the present writ petition. Stop. Next. Allegation of the petitioner is that the aforesaid private respondent is implicated in several criminal cases. Stop. At the time of filing the nomination, the details of the criminal cases are required to be disclosed in the nomination form. Stop. The private respondent did not disclose any details of the criminal case in which he is involved. Stop. Next. Paragraph. Further allegation of the petitioner is that the nomination form is required to be signed by 2 proposers.
1 proposers and 2 witnesses.
Acha, 1 proposer and 2 witnesses. Stop. The nomination filed by the private respondent, though discloses the address of the witnesses. What about the proposer?
Proposer, there is nothing. Witnesses' name is also not disclosed. Their signature is also required.
And proposer's name and signature, nothing is there.
Nothing is
Address is there. Where is the portion of the proposer?
Proposer portion, my lord, I don't find it anywhere.
I can see the witnesses portion. Where is the proposer's portion?
Sir, in this form.
It is not here.
Not here.
Next page. Next page also, no, it's not there. Acha.
Next page also same.
You have written now.
Witnesses, but neither the signature nor the name of the witnesses are mentioned. Stop. It has been submitted that the false information has been provided by the private respondent at the time of filing the nomination. Stop. The contention of the petitioner is that at the time of scrutiny, the application of the private, not application, the nomination of the private respondent ought to have been rejected on account of non-disclosure of relevant facts. Stop. That not being done, an objection has been filed before the competent authority, which is pending consideration. Stop. Next. The respondent number 4 could not be served as the matter is being taken up on an urgent basis. Stop. The State Election Commission is represented before this court. Stop. Next. Keeping the writ petition pending will not serve any purpose. Stop. Accordingly, the present writ petition is disposed of by directing the block development officer.
My lord, or the state election commission can also be created.
Party.
One.
Your representation is there. Is it there
Yes,
before
yes,
the
page 20,
page 20?
20.
Acha. Disposed of by directing the state election commissioner to take a decision on the objection filed by the petitioner.
Election commissioner.
If required, upon affording an opportunity of hearing to all the necessary parties for disclosure of relevant details. Stop. Next. A decision shall be taken in the matter at the earliest, but positively by 27th of June 2023. Stop. Learned advocate for the petitioner is directed to forward a copy of the objection forwarded to the state election commissioner and the relevant documents in support of his claim to the aforesaid respondent at the time of communicating the order of the court. Writ petition disposed.
But I am appearing for the state of West Bengal, opposing the petition.
Where is the petitioner?
But I have a preliminary point with this. Can I place?
Yes, yes.
But it's an election dispute matter.
Who are you representing?
I am appearing for the state and the
Very
state
well.
offices. But
State and the
state office of this.
state officers. Yes.
Well, this is first of all maintainability, because it is a barred under section 243(o) of the Constitution to interfere by courts in electoral matters. Notwithstanding anything in this Constitution, the validity of an election does not require. B. No election to any panchayat shall be called in question, excepting by an election petition presented to such authority and in such manner as is provided for by or under any law made by the legislature of a state. Therefore, this matter relates to a dispute in connection with the election. Therefore, it's a barred under Article 243. And in Purnos, right from Purnoswamy's judgment to just yes. But
I have a copy of the judgment.
Purnoswamy is there now.
Yes.
And also it has been relied upon in 2018, volume 18, SCC, page 141. That's State West Bengal State Election Commission and others versus Communist Party of India, Marxist and others.
This copy I don't have.
Anyway,
Anyway, the Purnoswamy is there.
Yes. It is kindly come to paragraph. Purnoswamy has been relied, The Lords will find kindly come to paragraph 29 of this West Bengal State Election Commission versus Communist Party of paragraph 29. There is merit in this discipline which is mandated by the provisions of the Constitution and enforced by the enabling state law on the subject must be maintained. But here the state law is there for redressal of the election dispute. Any dispute in regard to the validity of the election has to be espoused by adopting a remedy which is known to law, namely through an election petition. It is at the trial of an election petition that factual disputes can be resolved on the basis of evidence. The principle has been consistently adhered to in decision of this court. In Bodula Krishnasa Swansea, 3 judge adverted to the decision of the Constitutional Bench in NP Purnoswamy and Swansea, Lokhicharan Sen Eke Arjuna Hasan. After referring to it was observed. 8. In NP Purnoswamy, returning officer, Navagala constituency, constituent of this court has held that having regard to the important functions the legislature have to perform in democratic countries, it has always been recognized to be a matter of first importance that elections should be concluded as according to time schedule, and all controversial matters and all disputes arising out of elections should be postponed till after the elections are over,
so that the election proceeding may not be unduly retarded or protected in its conformity with the principle. The scheme of the election law is that no significance should be attached to anything which does not affect the election, and if any irregularities are committed while it is in progress and they belong to the category or a class of which under the law by which elections are governed would have the habit of issuing and enable the person affected to call it, they should be brought up before a special tribunal by means of an election petition and not be made the subject of a dispute before any court while the election is progress. The law is so settled that the Millard, any dispute in relations to the elections, whether Millard the accepted, not accepted, anything, any irregularity, any illegality, Millard, that cannot be taken care of Millard, until the election is over and the remedy is before the Millard. In that judgment, your lordships will find Millard. Millard, paragraph 31, Millard, that few lines, your lordship, that 20,000 candidates were uncontested, that was the subject matter there. This has said, Millard. Then in the middle, Millard, classitum E. Millard, kindly come to classitum E. This sentence is, thirdly, once the election process has been commenced, my lord has got it, Millard?
Yes.
It is tight law that it should not be interdicted mid-stage. But my submission is any type of, with great respect to your lordship, any interference amount to interdiction. Interdiction. Therefore, this is also not any type of what is this grievance here. Then that has not cannot be addressed. Even the kindly see there few lines after last one, first, second, third, fourth line. This court has been apprised the approximately. Kindly see. 1,700 complaints were filed and about 168 election petitions have been instituted. We are emphatically of the view that any challenge to the election must take a place in a matter which is known to law. My lord, now here your lordships will find, my lord, that the ultimately 33, my lord, paragraph 32 is regarding the prescription of time for fixation of the election petition is there. How many days? I am not give trouble to your lords. 30. For the reasons we are of the view that challenge in regard to the validity in the elections or to the uncontested in the Panchayat Samiti and Jilapur must also be pursued in election petition under section 79, one of the Panchayat. We have leave it open to any person agrees to answer. But this is the gist of the matters are related to Hasanujaman's case. But one judgment, Millard, that I have only one copy. Kindly just exclude on the print. 689. Millard, kindly keep print. Yes. Millard, this is 1985 volume 4 Supreme Court cases, page 645. SC Jain. No, sorry. Millard. I'm sorry. I'm very sorry. Millard. This is 689. 1985 volume 4 Supreme Court cases, page 689. Lokhicharan Sen and others versus AKM Hasanujaman and others. But that Purnaswamy, etc., all have been considered. But importantly, I want to place to your lordship. That's a very initial stage, Millard. The electoral roll, etc. These objections have been given. Court interfered with the matter. Calcutta High Court has allowed the writ petition. Ultimately, the Supreme Court said no. Millard, I am making it very short. The ultimate Supreme Court has said no. Once the election process has been commenced, any dispute, anything, only would be answered by them. Let kindly come to paragraph 21. As a result of this discussion, it must follow that the fact that certain claims and objections are not finally disposed of, even assuming that they are filed in accordance with law, cannot arrest the personal election in the legislature. Therefore, the election has to be on the basis of electoral within enforced on the date of making nominations. Therefore, election, the moment election, declaration, nomination, scrutiny is over, then from the date his comments, no one can challenge whether his name is added or not added, accepted, not accepted. Any representation has been made that has not been disposed of by the authorities, etc., who are there. But these are all election dispute that has to be decided only in an election petition. But here the case is that the objection is that their names were there, but in a scrutiny, their names have been cancelled. Anyway, my lord, after his making submission on merit, I will tell about the facts, but I will tell about fact. But section 93, subsection C, 1C. Section 93, subsection 1C of the West Bengal Panchayat Elections Act 2003. But this 93(1), subject to the provisions of subsection 2, if the court is of the opinion, A, that on the date of his election, a returned candidate was not qualified to answer. C, that any nomination has been improperly rejected. The court means, Chair Millard, the civil court. But the election dispute has to be raised. Therefore, this is the election nomination has been illegal, even for arguments illegally rejected. Then Millard, it is an election dispute, it cannot be brought. And on fact, I will tell you lots of stuff.
What are the matters, facts of the case? Use the microphone. Is anybody leading you?
Oh, yes.
Mr. Bhattacharya?
The judgments which are cited before the court with deepest of respect has no application for the simple reason all those judgments were declared in the context of assembly election and parliament election. There the court said if the election is delayed, there will be constitutional crisis because assembly has to be constituted every 5 years. But here the Panchayat, under the Panchayat Act, there is no such provision. There will be constitutional crisis because Panchayat, in absence thereof, the government is allowed to run under the West Bengal Panchayat Act. Therefore, the judgment which are cited must be read in the context which the court was decided. Mr. Bhattacharya, kindly come to me about this judgment first. Then, fact is that we were refrained from filing the nomination. In no case before the Supreme Court, this was a situation that someone was refrained from filing nomination. What the case before the Supreme Court in Lokhicharan Sen was defect in the electoral roll. And the Supreme Court said the delay in election ultimately may create a constitutional crisis. Therefore, the perspective is completely different. Here, the Panchayat election, Milord, has been declared permitting the persons to file nomination. They were prevented. If they were prevented, then Milord, the basic rule was not followed by the agency itself. And we are before the Constitutional Court to ensure a right to contest. My Lord will permit us to contest. And Milord, those who are preventing, they are getting the benefit of uncontested election. I prevent you and I get the benefit of my illegal activities, which Milord Constitutional Court cannot permit. Now, if your Lordship kindly Milord sees the Lokhicharan case, which my learned friend cited upon, Hasanujjaman, same thing. I just take your Lordship to paragraph 26. Paragraph 16 first. 16 of the said judgment. That this is the background which will not escape the notice of many of us. Paragraph 16. Hello, come to it.
Yes.
Holding the elections to legislatures and holding them according to law are both matters of paramount importance. On the one hand is the individual statutory right of franchisee. On the other hand is the constitutional obligation imposed by Article 168 that for every state there shall be a legislature. We find it somewhat odd that in the instant case, individuals whose rights are alleged to have been violated have not come to court at all. Not 1 out of the 8 lakhs. Persons who have come to court are members of a political party who claim to represent them. While we are on this question, it must be emphasized that election laws do not recognize political parties except in Rule 11C of the Registration Electoral Rolls. The election symbols so and so. The right to be included in the electoral roll or the challenge to inclusion of the name is a right conferred upon an individual and not upon any political party. The petitioners are espousing the cause of unnamed and undisclosed persons through a writ petition, which does not even claim to possess a representative capacity. The upshot of the petition filed by them is that some 3 crores of voters were being deprived of an opportunity of exercise their franchise in order that an investigation should be made as to whether the names of some 5 lakhs and odd persons should be included in or excluded from the electoral roll. The fundamental error from which the writ petition suffers, but this is the background on which this court will comes to a finding that if the elections are not held, there is likely to be a constitutional crisis. And in our case, but if a lordship comes with that holding a panchayat election every 5 years is a constitutional obligation. But if the elections are not held, there is no constitutional crisis. Under the Panchayat Act, the government can appoint administrator and run it. Therefore, these 2 cases has to be considered in the perspective on which the court decided. And in our case, I have also cited that the individual whose nominations have been refused, they are before the court, not the political party for them.
No.
And they are saying
the facts is here we have filed nomination. Our names were appearing in the website.
Sorry, yes.
Subsequently, for no reason, our name is disappearing from the website.
That's true. Well, a little bit of a distraction of facts. That's why I say we have not been allowed to file the nomination. If the nomination is rejected after the website, it was uploaded at the last occasion without giving us any opportunity, that amounts to denial of rights.
Paragraph 12. After scrutiny, there was no scope for cancellation. Scrutiny was done on 17th. Our name was appearing after scrutiny. Thereafter, for no reason, the name is disappearing.
And if your lordship again will kindly turn to the judgment which they are cited, kindly come to the relief paragraph. The court said, page 58. Sorry, paragraph 58. Now about reliefs. In this case, however, reliefs prayed for are not possible to be granted. It is not the petitioner's case that the electoral rolls in all the 294 constituencies of West Bengal have not been revised in accordance with law. They have made allegations only with respect of constituencies, and omnibus complaints were filed only in respect of 2 constituencies, namely Bartola and Bhatar. Although there was no electoral rolls prepared in accordance with law for Bartola and Bhatar constituencies, the general election of the entire state cannot be held up, as electoral rolls are prepared and published constituency-wise. It is therefore not possible to hold up the election in respect of all the constituencies. Now, this was the relief which the Supreme Court refused. But in our case, we are not asking for the holding up of the elections. We say we were there, you permit us to contest, and that will not deter in any way the election process. The judgment ratio has to be read in the background of the facts laid before the Supreme Court and what is the outcome. Outcome is that this is bad, but relief cannot be granted at this stage. In our case, relief can be granted because the petitioner's names were there uploaded. How and in what way they have deleted it? That's the fundamental question.
Only thing is there that after scrutiny, only withdrawal is the scope for a similar order was passed.
Who has taken the constitution? Now, my lord, I, 1 minute. My lord, regarding the submission of Mr. Bhattacharya, that's no constitutional requirement. I have already submitted, my lord. This is a constitutional requirement under Article 243O. Because this has been amended in 96 or 97. This is my lord, just exactly date is 96 or 97. Therefore, it is a constitutional amendment. And my lord, if your lordships kindly come to provision 243 age election. Elections to the Panchayat 243K. And this is for a period of 5 years. Superintendent elections shall vest in the state election commission constituency. The 243(2) subject to the provisions of any law made by the legislature of state, the condition service and tenure state elections on the governor status and so. And the election is for a period of 5 years. The constitutional requirement. What was there, my lord, earlier pre-constitutional in our state, West Bengal Panchayat Act 1973 has come into force. Correct. That time, this constitutional mandate was not there. Like the moment, my lord, this Constitution Part 9, which has been inserted with effect from, my lord, the 1st June 1993, 73rd Amendment 1992. Now, my lord, all act has been amended. Therefore, it's a constitutional requirement for a period of 5 years only. The question of extension, etc., my lord, that doesn't requirement of the 5 years is expiring. My lord, I am not on that, my lord. Just to meet the submission of Mr. Bhattacharya making a distinction. Even let's assume Mr. Bhattacharya is saying 6 months. Let's assume, my lord, the election of the parliament has not been done. What would be happen? 5 years? Please, Mr. Bhattacharya, please.
Sorry.
Sorry, please. If the 5 years not happen, the Prime Minister has to resign and goes to the President of India. President of India, by an ad hoc, make appointment of the Prime Minister for a particular period. Or President of India can exercise the milord, impose a president rule. In a case of a state, if the election is not held within 5 years, Chief Minister has to resign. It is absolutely the discretion of the governor, that honorable governor.
Here, nobody is
there.
the election process.
No, I am coming. Question is, beloved, whether it's an election dispute or not. My learned friend has said initially that obstruction has been created. It's not there. Later on, he has changed. On 17th June, I will one judgment of the division bench of the High Court, that in respect of municipal matters, municipal and Panchayat. The division bench, in 2022 SCC online, Calcutta 336, Mat 18 of 2022, Justice Orijit Banerjee and Justice Kaushik Chandra.
Just give me a copy.
Kindly excuse me, just now my juniors, I am giving it. Paragraph, Molloy Banerjee versus State of West Bengal in paragraph 11. We have given our anxious consideration to the submissions of the respective parties. We are constant to agree with Mr. Shah that it is too late in the day to direct the Election Commission to accept the nomination of the appellant. A statutory time schedule is prescribed in the 1994, following which the Election Commission has published the final list and contested kind of so and so. Today, we permit the appellant file number in all, but the entire process will be disrupted. This is it. Here is the case. Yes, the appellant say he was prevented from filing his nomination paper by the state administrator. Sitting individuals, we are not in a position to adjudicate such factual issues. In fact, that was also in the state election 2018, paragraph 16. Mr. Bhattacharya appeared before the Supreme Court also. They have said, no, we are obstructed. CPM party, they have said that they have been obstructed. In paragraph 13 of that judgment, said, beloved, I will just after finishing that I will come there. Beloved, therefore, this has been it is not accepted. In kindly come to beloved the 2018 SCC, same argument. Mr. Bhattacharya argued there on behalf of the CPM party there. Same argument.
Which paragraph?
Paragraph 813, kindly see.
13.
আমি সিনিয়রের নাম বলবো না জুনিয়র নাম বলবো বিকাশ না নামটা তো আমাকে বলতেই হবে আগে paragraph 13 kindly see. On the other hand, it has been argued on behalf of the first respondent that the High Court had been constant to issue a direction for the accent or inelectable after suffering material was placed before indicated that candidate has been prevented from filing their nomination. It was asked as a result of the violent activities of the supporters of the ruling party in the state, a situation had arisen where it was not possible to file nomination paper. Personally, hence the directions which are issued by the High Court subserve the cause of free and election. There the Supreme Court has said, no, we can't interfere at this stage. If you have any grievance, go before the civil court. Under Millard, in this matter, what has happened, since the 30 days have gone, expired statutory, the Supreme Court exercised the power under Article 142 of the Constitution and extended the time for more than another 30 days, go before the civil court. There also same allegation, Supreme Court did not accept that. Millard, I have just seen that. Here in this case, what has happened, Millard? Your lordships will, I don't know whether your lordships have gone to the, in other matters, regarding the schedule of this election. Date of nomination, your lordship has seen. Date of, Millard, the filing last. Date of scrutiny, lordship has seen that. Millard, on 17th, on 17th at the time of scrutiny. Millard, if someone was not present, nobody is, Millard,
No, this case is the scrutiny was done.
no, that's exactly I'm saying to your lordship. They are saying that it is in the list, portal, his name is being shown. It is his case. It is his case. Portal and another is not a statutory obligation. It's maybe what has happened. I am reading from the order, Millard. I can.
Which order?
Rejection of his nomination on 17th June itself.
Whose rejection?
His case. This
No reason.
Muslima Begum.
But then it has been submitted that no reason has been given for rejection.
No, reason he was not there. What can be? She was not there. What can be done? I tell you, Lord, Millard, kindly see. Yes, my lord, if you do not mind, Millard, can I just
No, just read it out from there.
hand over laptop, Millard?
No, read it out.
My lord, see. Venu Bhangor 2 meeting hall dated 17 June 23. GAPS constituency name and Bhangor 2 Roman 3 name of the intending candidate. Muslima Begum, date of submission 15 June 2023. Time of submission 8:01 p.m. Millard, submission was, it was up to 3 p.m. After this, I will tell you, let's say another incident. 8:01 p.m. Nomination was received on 15 June 2023 at 8:01 p.m., which was beyond the prescribed time for filing nomination as per Form 1, published by the District Panchayat Election District South Panchayat. Moreover, nomination papers were submitted by force under duress when the nomination venue was captured and ransacked by violent and mob carrying arms, rods, sticks, and stone. 2. During scrutiny, other candidates raised objection about nomination papers submitted beyond the prescribed hours of submission of nomination paper as per Form 1, noticed by the District Panchayat election officer and District Magistrate Southern. 3. The matter was brought to the notice of the District Panchayat election officer and District Swanso, seeking clarification of further. The District Panchayat was South to Bhide Swanso instructed understand to follow the instruction of SEC or Bhide number Swanso dated 17 June 23. That's a normal. No. In view of the instructions after prescribed time of filing nomination, as per Form 1 notified by the District Panchayat or District of South is hereby rejected. My lord, kindly pardon me, Millard, for saying so. Since I have appeared in the matter, my learned friend was appearing before my Lord Justice Mantha. My Lord Justice Mantha. Millard, their case was that there was a complete obstruction and they could not file the nomination. My Lord Justice Mantha was pleased to direct us to give our explanation. Millard, on the last occasion, I appeared before Justice Mantha, and from my memory, just I tell your lordships, what has happened on that day. And Millard, this group, I have shown the video, I can show it to your lordships, the video even. This group, along with 2,500 persons, entered into the office of the video, forcefully said them to accept the nomination. Almost on the gunpoint. Almost on the gunpoint. The nomination paper under pressure of them. The nomination paper had to be received from 9 o'clock to 11 o'clock. The video was surrounded by the total mob. 2,000 to 2,500. This fact was placed before my Lord Justice Mantha. My Lord Justice Mantha, so far the law and order situation concerned, asked us to file an affidavit within 15 days or 29. He is aware anyway, my Lord. And the CCTV footage also. So far the law and order situation is concerned, that is being taken care by one of the question is, my Lord, the rejection has been made on the ground that they have, this is the stand, this has been, the copy is not with me now. The video has also lost a complaint before with the officer in charge. The hooliganism which has been done by them after 8 o'clock. There were nomination papers had been filed after 8 o'clock, and this is the ground, my Lord. His scrutiny, she was not present in the scrutiny. What can be done?
So is it at the scrutiny stage that the nomination was rejected?
Yes, yes. That's exactly I am telling you.
But then the submission is, I do not know what the fact is.
Yeah,
The
right.
submission of the petitioner is that after scrutiny, the name was appearing in the list.
No. But his submission is this. His names were even also 17th evening in the
Up to 20th.
up
Till finally.
till final list is this is his case. Website is not within the statutory things. Whether the website has been corrected or not corrected, that's one of the matter. But the matter is whether the rejection has been done by the competent officer within the time of the scrutiny or not. My Lord, I am
Is the petitioner made aware that her nomination has been cancelled?
My Lord, if she doesn't remain at the time of scrutiny, all has to remain present. If she doesn't remain present in a parliament election, my Lord, I have to remain present, leaving aside all my jobs.
And at the time of filing nomination also, the candidate is required to remain present personally.
Personally, what has
At
happened?
the time of scrutiny also, the candidate is required to
Candidate
remain-
or his representative,
is
or his or
required-
her representative, or the election.
You say that nobody from the petitioner number 1 was present over there. Nobody.
No one was there. My Lord, kindly see what has happened. Candidate has to remain present at the time of filing nomination. Nomination was given by force after 8:01 p.m.
I will require a copy of what you read out.
My Lord,
Rejection.
can I print? Can my
Yes,
junior
yes,
can
yes.
print it
Print
and give it to your Lord?
Yes,
My Lord?
yes.
Just kindly, excuse me, my Lord.
Yes, it's permissible.
In fact, it is such a short point of time.
Yes.
That's the reason. Normally, I am not appearing. Since a Bhangor's matter, I appeared before Justice Mantha.
Very well,
They have
yes,
requested me.
Hmm.
Therefore, today, what I was submitting to your lordship, let's say the dispute. Let's assume for the argument's sake. Let's assume for the argument's sake. This scrutiny rejection was bad. This since it is in the list, their names were there. Therefore, a presumption can be drawn. No, scrutiny, they were allowed. Let's do it. Therefore, it's a dispute. And it is an election dispute. Now, my Lord, whether it is required to be proved by way of evidence or not. My Lord, I will give this. Just excuse me, my Lord, print point, I will give you the printout. My Lord. This has happened. This has happened, my Lord. Therefore, my Lord, I respectfully submit to your lordship. My Lord, I have referred to the 3 judgments: Purnaswamy's judgment, West Bengal State Election Commission's judgment, even the Hasanuzzaman's judgment. And my Lord, the very particularly, these sorts of allegations were there in the Supreme Court, the 2018 matter.
And also in the municipal election of.
And municipal election division bench also, my Lord, I have. Judge Sahib, this is copy.
No, that copy has not.
My Lord, I am just, my Lord, I am at hand. Both the 2 copies. My Lord, these are my submissions, my Lord. My Lord, would your lordships will continue with the matter, my Lord, or some break, or I don't know.
No breaks, because we have got an early rising today.
Oh, yes.
So many urgent
No,
matters.
my interest on you, nothing. one of the matter at 2 PM, your lordship has fixed it. That's the
Yes,
reason.
I'll continue.
Okay, okay. Just for, don't take it otherwise, my lord, I just,
Yes, yes.
I needed 5 or 10 minutes time. That's the idea.
Go, go.
Deeply obliged, your lordship. Hey, Joseph, duto তুমি দিয়ে দাও।
That my senior is there, like, only to assist him. Let kindly, sir, kindly takes up page section 49 of the Election Act.
নতুন কিছু বলবি নাকি? আমার পঞ্চায়েত একটা দিন না, ওইটা তো।
Clause 6.
এদের নাম নেই। এটা আমরা পড়লাম। Clause 6, 49(6). 49(6) 51(3) পড়লাম না, 49(6). এই অর্ডারটাই তো আমরা পড়ে শোনালাম অ্যাপ থেকে। That is the order.
Which section are you referring?
49 subsection 6.
49(6). Scrutiny.
Scrutiny.
Kindly allow me to assist him.
Yes.
পেশ করো।
Kindly similar clause 6, the Panchayat returning officer shall endorse on each nomination paper his decision accepting or rejecting the same, and if the nomination paper is rejected, shall record in writing in brief statement of his reason for such rejection. Therefore, whatever is to endorsement or reason, the returning officer, he has to give it on the nomination paper itself and in presence of the parties. And we were present during scrutiny. There was no decision, and now the decision now they are producing in a separate sheet. Now this is, they are inviting investigation once again. But why can I tell you, Lashim, on 21st, in another matter in the same constituency, we have approached this honorable court. Court has passed in order in presence of the state as well as the election officer, election commission. There was no such decision on that particular date. This particular sheet was prepared subsequently, and there was no endorsement made on the scrutiny nomination paper on the particular date. The entire thing was recorded in terms of the direction of the division bench, should have been recorded at least. That if they produce that recording, that will be in any event, this decision cannot be on a.
But then tell me, if there are factual disputes, Mr. Bhattacharya, you also listen. If there are factual disputes, can these be gone into in the writ petition, or an election dispute will be the only remedy?
Lord, election dispute can be a remedy when there are stray cases, 1 or 2. But here the nomination process will not initiated with the intervention of court. Without the court being satisfied that these people are prevented, without given the police protection, they went to file the nomination. The scenario as it was there with the police protection is obvious. And this ground reality is so serious and so precarious. That's why these questions come. The nomination papers, rejection, no factual determination is necessary. As per the requirement of law, he has to show that he had recorded his reasons on the date of election nomination. In absence thereof, everything is bad. And look, what is the basic principle of election? Why are they scared of participation? They should welcome that, yes, come and participate. If there are certain mistakes, it should not stand in the way. The foundation of election concept is being destroyed, and all it is go before the election petition. This is not 1 or 2 individual. In MLA and MP elections, how many election petitions are there? Here, about more than 65,000-87,000 candidates. Amas chaos. To prevent that, the Reed Court, being extraordinary power holder, would definitely intervene. I just give you also a reference of the cases. You must remember, the case would be cited when the Tamil Nadu government dismissed all its employees by stroke of a pen. Then the matter went up to the Supreme Court, High Court. High Court said, now go before the tribunal as per the State Administrative Tribunal Act. Now the Supreme Court said it is impossible that Thousands of employees who go to the tribunal. The writ court should intervene. And writ court intervene under the special circumstances and will pass the order. Therefore, the extraordinary power has to be exercised in an extraordinary situation. That situation is before your lordship. And my lord is very correctly interfering to ensure that the election goes on. No selection, but election. That is the more fundamental.
But new thing has been said now.
And one more thing.
And
that in-
another important thing, what Mr. Banerjee probably could not follow me. I said that if there is no election of the assembly and parliament, there is a constitutional crisis. No one can take care of that. But if the election is not held, president's rules cannot be imposed. President rules can be imposed when there is a valid assembly, not beyond that. And that's why the court said there will be a constitutional crisis. But in the panchayat election, though every 5 years they have to hold the election, but if it is not held or delayed, there is no crisis.
Very
That the
interesting
government under the Panchayat Act can take care of.
very interesting question. Is the election is being held under the constitutional provisions? 243(o), the moment Miladi chapter 9A has been amended under constitution, all the persons, Milord, even a panchayat member is holding a constitutional post. MLA is holding a constitutional post. MP is holding a constitutional post. It is within the constitutional scheme. Pre-1991, situation was something different. Now it's a constitutional crisis from the grassroots level. Whether Milord, in the vacuum, Milord, in the Ragnam, what would be arrangement? That's a different thing. That's a different thing. But it is a vacuum. What would be done? What court will pass the order? That's a different aspect of the matter. From a plain and simple interpretation. Therefore, with great respect to Mr. Bhattacharya, he is much senior than me and very good friend of mine, and also one of the friend in also in the another house. That Milord, I'm sorry, I'm great respect. I disagree with Mr. Bhattacharya that this is not a constitutional post. It's a constitutional post, constitutional crisis. Maybe someone is, my Milord, kindly see that my Mr. Bhattacharya said so many these things. Milord, kindly see so many obstruction, etc., etc. So many things have been done. Last election, before the Supreme Court, when the Supreme Court was being heard the matter, only 168 election petitions were filed.
Out of 1700 complaints.
Out of 1700 complaints. And my lord, here in this judgment, Mr. Bhattacharya's clients, I mean Communist Party of India Marxists, were given liberty to file election petition for 20,000 uncontested seats. But Mr. Bhattacharya's client, the CPM party, could not file a single petition in terms of the judgment of the Supreme Court. Therefore, it's very nice to say, my lord, this has happened, this has happened, this has happened, that is happened.
Because of your situation, no petition to be filed.
Your situation, Mr. Bhattacharya, kindly do not allow, do not speak something that where I will be compelled to open my mouth.
Please restrict the
Now,
submissions
but
with
this-
regard to
the-
this
the-
matter.
now-
We hardly have time.
Now,
in hand.
therefore, now, therefore, my lord, and see, in the writ petitions, is there any single averment?
That they were present.
They were present in at the time of scrutiny. Paragraph. Come. Kothay?
In the middle, neither was any endorsement
presence
made on the
No, no.
the petition in
What-
terms of section 1.
No, kindly see, where is the averment? The petitioners and his agents or authorized persons?
Yes,
Kindly read.
They recorded
Wait
their
a-
presence by affixing their signature on the attendance sheet. In fact, neither the assistant panchayat returning officer nor any other person raised any objection at the time of scrutiny. Neither was any endorsement made on the nomination papers of the petitioner in terms of so-and-so rejecting the nomination paper. On contrary, the petitioners were informed that their nomination paper have been accepted.
কোথায় রয়েছে?
What more I can say?
No, you were present and you have affixed the signature is the statement. The other persons may be remain present. The other persons may be remain present. The petitioners or their representatives were present and affixed the signature. Is this statement is there? Therefore, my lord, this is a question. My lord, is a disputed questions of fact. I must say to my lord. If he is having any grievance, rejection has already been made, and therefore, in this case, my lord, I don't know, my lord, whether what order has been passed by your lordships in other matter. I do not know. But the point is, my lord, once it has been rejected, let's assume it's an illegally rejected. Let's take his best case that illegally rejected. No reason is there, illegal things. Does it come within the ambit of the election dispute or not? If it comes within the ambit of the election dispute, then the writ court would not interfere. This is my humble submission. That's all. জোসেফকে দুটো কাগজ দিয়ে দাও প্লিজ। এনেছো?
Very well. Hearing is concluded. It will appear for orders on Monday.
Milord, I will give this later on.
Please do.
Milord, just 10 minutes.
The rejection, my lord, I'm handing over right now. The judgment is coming, my lord. I'll hand over to the
Molay Banerjee.
একটাই জোগাড় করেছি দিচ্ছি।
হ্যাঁ, মলয় ব্যানার্জি কি?
মলয় ব্যানার্জি কপি, yes, judgment-এর copy.
Oh yes, মলয় ব্যানার্জি judgment. Yes, sir.
Yeah, I have the similar point, but I argued yesterday.
No, it's all right. Milord, there I have this, which matter?
Bangor matter, same point.
No, before that, the other matters are there. ওই ম্যাটারটা এটা
Item number 10 is similar matter.
কত নম্বর আছে ওই ম্যাটারটা?
4 ভাঙর is 4
আমি না, আমারটা ওটা তো
একটা ক্যানিং আছে, একটা ভাঙর আছে।
ক্যানিংটা কত?
ক্যানিংটা হচ্ছে 7।
ওটা ব্রিফটাতে
ক্যানিং
না, ভাঙর একটা ভাঙরটা ওটা তো
নেবে না, এটা নেবে।
This was item number 7. Which one is same? You said 10.
10.
Same.
Milord,
All
there
right.
also order has been passed. Rejection.
Then I require the order.
Order. ওটা তো order দিয়ে
Item 10. Order in item 10. It will be called on. Please wait one by one. Item 8.
মামলাটার নাম কি?
Sheikh Kiamuddin.
Here, the point is, the petitioner was intimated about the rejection of his candidature from one of the constituency. He had originally submitted his nomination for 2 constituencies. For both the constituencies,
এই
8 লেখা আছে
এখানে আমার order আছে, একটু জল দিতে বলুন তো। Yes.
for both the constituencies, the nominations were accepted. It appears.
My lord, may I hand over the 10, item number 10?
It will be called on.
Called
Please
on.
do.
Now, Lordship, kindly come to directly page 26. This is the receipt of the documents given by the nomination paper for Mustadin 1113. This is one constituency. And page 18, Lordship, another.
You are Sheikh Kiamuddin.
Sheikh Kiamuddin.
Yes.
He had submitted for 2 constituencies, nomination for 2
Right.
constituencies. Now, Lordship, he participated in the scrutiny process. Now, recently, my learned friend, Mr. Ahmed, was showing one section to your Lordship, section 49, that where the purpose of the scrutiny and the order has to be written. Therefore, that scrutiny which was conducted on 17th, it should have been written, and summary rejection,
Should have been.
if his candidature was rejected
Yes.
on any ground, that should
Right.
have been reflected on that
All
day
right.
itself.
Yes.
In view of section 49, I'll cite that.
Ah.
Now, on contrary, then once this was done on 17th, after that, I made a representation for withdrawal of my candidature for one of the 6, one of the constituency. This is on page 28. And this was, and it was ultimately withdrawn on, this was 17th, I intimated, And ultimately on 19th, kindly come to the impugned order, page 33. It was on 19/6/2023. 2 days after the scrutiny, his candidature was rejected by them. With reference to the above mentioned subject, this is to apprise,
But
I have
this is in
looked into
respect
the
of
matter.
only one constituency.
One
What
constituency.
about the other?
Other I have already withdrawn after the this
Oh, one you have withdrawn and the
Withdrawn.
other has been cancelled.
cancelled.
So you are out.
After the withdrawal, this was. So I was out. No
Why did you
documents were
withdraw
pending.
the other seat? You did not want to.
Because there is a bar that I cannot contest from 2 constituencies.
Yes.
Initially, I have taken the nomination papers for 2 constituencies. I have filed the nominations with all documents. On 17th, there was no intimation given to me that whether it is rejected because everything was in order. On 19th, once I withdrawn the candidature on 17 by giving the letter, on 19 it says that your candidature is rejected on this ground. So it is basically, in my humble submission, a candidate becomes a candidate once his name are published in the final list of candidates in terms of section 50. Now, Lordship, kindly come to.
But then your name was never published.
My name was never published because 19th was the 20th was the date for the last date for the withdrawal, and that is a continuous process. Now, kindly come to section 49 and for 50, Lordship, I will read, and that will do my purpose, Lordship. Section 49, Lordship, says that scrutiny of nominations. I am on the clause 2. The Panchayat returning officer shall then examine the nomination papers and shall decide all objections which may be made to the nomination and may either on such objection or on his own motion, after such summary inquiry, if any, as he thinks necessary, reject any nomination on any of the following grounds. Thereafter, the grounds are there that on the day fixed for the scrutiny of nomination, the candidates either is not qualified or is disqualified for being chosen to fill the seat under any of the following provisions that may be applicable, namely Article 243F of the Constitution of India and Part 2 of this Act, that there has been a failure to comply with any of the provisions of Section 45, 46 and 47C, the signature of the candidate or the proposer on the nomination paper is not genuine, that the proposer is not a voter of the constituency concerned. Nothing in this section in clause A or clause B or clause C of subsection 2 shall be deemed to authorize the rejection of the nomination of any candidate on the ground of any irregularity in respect of a nomination paper, if the candidate has been duly nominated by means of another nomination paper in respect of which no irregularity has been committed. The Panchayat returning officer shall not reject any nomination paper on the ground of any defect which is not of a substantial character. The Panchayat returning officer shall hold the scrutiny on the date of appointed in this behalf under clause B of section 43 and shall not allow any adjournment of the proceedings except when such proceedings are interrupted or obstructed by riot or open violence or by causes beyond his control, provided that in the case of objections is raised by the Panchayat returning officer or is made by any other person, the candidate concerned may be allowed time to rebut it not later than next day following the date fixed for scrutiny. The Panchayat returning officer shall record his decision on the date to which the proceedings have been adjourned. Now, Lordship, it ought to have been recorded on 17th or 18th. One day can be adjourned for writing the reasons. Now, it has been written on 19th. Now, for the purpose of this section, the certified copy of the entry of the electoral roll for the being time force constituency shall be conclusive. Immediately after the nominations papers have been scrutinized and decisions accepting or rejecting the same have been recorded, the Panchayat returning officer shall prepare a list.
What is the reason recorded for
Yes.
the rejection?
My lord, kindly come to page 33.
Yes.
Now, according to section 8 of the West Bengal Panchayat Act 2003, no person shall be entitled to stand as a candidate for election for more than one constituency or seat. Hence, the nomination paper filed by Sheikh Qiyamuddin from Muradia 11-13 has been cancelled during scrutiny. Meanwhile, his nomination for Murad has been found to valid upon this scrutiny. He was not made a candidate at that point of the time. During this scrutiny, he had participated. He had submitted the nomination. He was not chosen to be the candidate at that point of the time. So either it has to be rejected or accepted. Once both nominations are accepted, then there is a scope for withdrawing it. And he has withdrawn from one constituency. That is why that withdrawal provision is there in section 50, Lordship. Any candidate may withdraw his candidature by notice in writing, which shall contain such particulars as may be prescribed and shall be subscribed by him and delivered before 3 o'clock in the afternoon on the day fixed under clause C of section 43 of the Panchayat Returning Officer. So this was my right to withdraw from one constituency. So it was the situation where I applied to contest from 2 constituency.
But now this matter will be an election dispute. I don't think the
Now,
DM can take a decision on this now.
the order, Lordship, the only thing is that the
93C,
order
my
of,
lord.
this order of block development officer, this order is under challenge. If this does not fall within the provisions, then this is the order without the jurisdiction, Lordship. He could have cited a reason on 17 that you do not give this document, or you do not.
This illegal rejection. This when a formal order is there, then an election dispute is to follow. This cannot be done.
This was a withdrawal within the time.
My lord, election dispute part, my lord, elaborate submission has been made. I only want to meet one submission of my learned friend, my lord. If I may, my lord.
Why? If it is sent for an election dispute,
No,
why
my lord,
make
my lord,
submission
please.
here?
Very well, my lord.
The petitioner is aggrieved by the rejection of his nomination made by the block development officer on 19th of June 2023. Stop. The court is of the opinion that the said rejection may be a subject matter of an election petition. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Dismissal of the writ petition will, however, not stand in the way of the petitioner to file an election petition in accordance with law, if so advised.
Grateful, my lord.
অ্যাপিয়ারেন্স দিসনি বলছো তো একসাথে করা আছে 7, 8, 10 7, 8, 10 একসঙ্গে লেখা 7, 8, 10 একসঙ্গে করা আছে
HON'BLE, I am for the petitioner here in this case, I have been declared, I have been destined by nomination paper. On 15th, I have made a complaint. Kindly come to page 31.
Why such a voluminous petition?
There is a 20 candidates.
20 candidates. Last date was 15th. Today is 23rd. How can the court grant relief?
On 15th, I have sent that representation to the election commission.
Then file election petition, nothing doing now. Please
And
come.
also, that is, I have purchased the deposit the fees.
You ought to have come earlier. I have allowed prayers. But then it is only after you got to know.
Constantly said. That is why I am
Constantly
not
threatened, I
able to
cannot
come.
help. Please come. The grievance of the petitioners is that they were prevented / obstructed from filing their nomination for participating in the Panchayat election, 2023.
And 15th June, I have submitted a
The
complaint.
petitioners submit that.
Page 31. Also page 61, I have deposited the fees also.
On the self, that on the 15th of June 2023, objection seeking intervention was filed by
our political party.
By the political party which the petitioners are representing before the Commissioner of the State Election Commission, but the same has not been considered till date.
There
Stop.
are 32 plus before the governor also.
Representation was also filed before the Honorable Governor. Stop. Next. It appears that The last date for filing the nomination was 15th of June. The date for, the date for scrutiny of nomination was 17th June. And the last date for withdrawal of candidature was 20th of June 2023. Stop. The petitioners have approached this court on 23rd of June 2023. Stop. Next. I am afraid that at this delayed point of time, the prayer of the petitioner for filing the nomination cannot be accepted. Stop. It will be open for the petitioners to approach the appropriate forum for remedy of their grievances, if so advised. It petition stands disposed of.
order to দিয়ে দিচ্ছেন
10, same order as 7.
Milord, I'm only handing over the
Yes, please. Yes, yes.
I mean led by Mr.
এটা item 10 এর ফাইলের ভেতরে ঢুকিয়ে দিন।
But only one thing, Milord, these documents are produced by the state. Kindly notice this.
Yes.
State, Milord, they are our officer. State's officer, Milord. The PRO is the officer. Yes. PRO is the officer. Yes.
Please call the daily list matters. Oh, there is a supplementary also.
Second
What is supplementary?
Supplementary is 1 and 2 same matter.
1 is
1 and 2 same.
1 and 2 same. Yes, 1 and 2.
Same facts.
আপনি বললেন 5টা আছে, 5টা আছে বললেন। Very well. তার মানে 3টে আছে তো? ঠিক আছে।
Milord, তুই কত কোনটা
সেটা তো আজকের লিস্টে আছে।
4917
এটা সাপ্লিমেন্টারি।
14 এটা কত নম্বর লিস্টে আছে?
আচ্ছা,
সেকেন্ড
এটাতেও দাদা
নামটা বলো
তরিকুল ইসলাম।
এটাতে সাপ্লিমেন্টারি কজ লিস্ট, এটা তো সাপ্লিমেন্টারি কজ লিস্ট, যেখানে একদম করে বুঝবেন
সঞ্জিত কুমার মন্ডল।
কোনটা কি
তরিকুল আর সঞ্জিতের কাগজ আছে?
বলো, এটা তো সেকেন্ড সাপ্লিমেন্টারি কজ লিস্ট করে দিন, বলে দিন এটা সেকেন্ড সাপ্লিমেন্টারি কজ লিস্ট করতে, তা না হলে অসুবিধা হবে না, আইডেন্টিফাই করতে পারবে না কোন মামলা। রেকটিফাই করে দিতে বলুন ইমিডিয়েটলি।
এরপর কোনটা ধরলো?
তারিকুল ইসলাম।
Milord, same as that item 7, but 7 and 7 and 10. But Milord, here also the scrutiny is cancelled, but order is not with me, Milord. It has just now given.
Will the printouts come?
Print of earlier matters?
No, earlier matter.
Earlier 2 matters they have given. This order
It has to be brought. Milord, it has to be brought.
Yet to be written.
Most of the day we can hand it over to your Lord's court officer. Otherwise, Milord, kindly appreciate this. This is just now it is served.
No, the matters are moved on urgent basis.
I understand, Milord. I understand.
And do you think that there are
Yes.
same?
Rejection, same.
Please get hold
No,
of.
that's right. I will get.
Second supplementary list, item numbers 1 and 2 will be same as item number 7 of the first supplementary list.
Milord,
বোঝা গেছে?
ওই কোথায় গেল? ললিত কোথায় গেল? ওই পিটিশনটা দেয় আমাকে, কত নম্বর আইটেম ওটা? এটা আইটেমটা কত? কে দিচ্ছিস? কি দিচ্ছিস?
সিরাজউদ্দিন তো আপনি দিয়েছেন।
এই সিরাজউদ্দিনের petition?
না, সে দুটো হবে না।
Milord, the judgment of division bench.
You want
In-
it handed over?
No, print.
Which one did you hand over?
7.
আচ্ছা, this is
Rejection order.
আচ্ছা, ঠিক আছে, এটা ঢুকিয়ে রাখুন তো, ওইটার ভেতরে 7 নম্বর মামলার ভেতরে ঢুকিয়ে দিন। মুসলিমা বেগম।
আমার ওই চিপের কোটে
মুসলিমা বেগমে।
শর্মা কোথায় গেল?
তার আগে একটা আছে।
Call 3, দিলীপ কুমার রে।
Made solution. And Milord, the candidate Milord was not allowed to Milord file their nomination.
Not allowed to file
Not allowed to
nomination.
Because Milord, they had been prevented by the police authorities and they had been Milord brutally.
Why are you so late?
No, Milord, I had Milord taken out a mail communication to the commission on that very date when the
Yes.
state of incident happened. Your Lordship would find it.
I'll grant you liberty to file election petition. Please come.
If I could, my lord, only indicate, my lord, since, my lord, I was even not allowed to, my lord, participate and, my lord, submit my nomination. My only prayer before your lordship, even, my lord,
You ought to have come a bit earlier. Nothing
I
else.
had, my lord, tried to explain what has prevented me to, my lord, come up before lordship. My lord, my mail communications, my lord, has been, my lord, repeatedly fallen on them. And one of the ground, my lord, which I have taken, that they had, my lord, sat tight over my mail. There was even not a single acknowledgement, but their duty was, my lord.
Item 9. Item 3, same order as item 9.
এটা হচ্ছে ক্যানিং ওয়ান
ঠিক আছে?
এটা বলবে
I'm grateful.
আগে কত নম্বর ডাকবে বলছি
কত নম্বর এটা?
এখন তো
Daily list. Daily list matter call. কি হয়েছে? Item number 3 in the second supplementary list.
Yes, yes.
Was
Your
anybody
lordship has just
appearing? Was anybody appearing for this?
সেকেন্ড সাপ্লিমেন্টারি
Mr. Mahato, Mr. Bandyopadhyay, were any of you appearing for this state? No,
In second supplementary, item number 3, we are not.
you are also not appearing.
I have not appealed.
No, did you serve?
No, my lord,
Did you
I could
serve?
not, I could not serve to the state. my
তাহলে
lord.
আর করতে
It's my
কাজ।
fault.
কেউ নেই। Yes. Item number 4.
Grateful.
সিরাজউদ্দিন
না
এটা এটা কোনটা সিরাজউদ্দিন দেওয়ান
Vishaka Mondal. I am for the petition led by Mr. Bhattacharya, my lord. Sir, আমাদের matter.
এখানে রিজেকশন অর্ডার আছে
This matter was heard, my lord, the last occasion at the request of Mr. Saptangshu Basu, it was kept today.
Yes.
Nothing new to argue. Only thing, my lord, uncontested election
Yes.
benefit is enjoyed by those people who are prevented. I prevent you, then I get myself declared uncontested.
No, I am
This-
appearing for,
Honorable will take care of it.
my lord, I am appearing for the state in this matter.
Yes.
My lord, in this matter, so far the uncontested is concerned, my lord, in terms of sectionটা কত জানো? Just 1 minute. Section 64B of the West Bengal Panchayat Elections Act. My lord, Form 12, the candidates have been, my lord, declared. But the result, my lord, declarations have been done. My lord, so far the uncontested candidate is concerned, those who was saying that they could not file a nomination, my lord, I am, just please, I am covered by the West Bengal, that judgment, my lord, 2018, 18 SCC, page 141, which I cited. There the Supreme Court has granted leave, paragraph 31, and ultimately paragraph 34, that Supreme Court has granted leave to go and file the
Election.
election dispute.
My lord,
For-
the Supreme Court,
That is
Mr.
not
Banerjee,
a,
let him complete.
sorry,
Mr. Banerjee.
my lord, because I am, sir.
No, whatever you are,
My
Mr.
case-
Bhattacharya, you will sort it out. You will
Your
No, no.
state's submission is that the election dispute is the only remedy that is.
The election dispute is remedy. Apart from that, my lord, I am submitting that they are now trying to, they are seeking for a relief, that your lordships kindly see, the prayer is that prayer is, my lord, just 1 minute. Prayer is, my lord, kindly see, issue of writ in the nature of manner commonly esteemed to cancel on a set aside and a coerce or rescind the process of nomination in ensuing election process and direct for a de novo nomination. Well, this is not permissible under law. It's an election dispute to go and get it set aside. Issue a writ in the nature of mandamus commanding the respondent authority to each of them to cancel or set aside a coerce or rescind the decision or rejection of nomination form of the petitioners by the concerned respondent. Therefore, my lord, that is also covered under 93C of the West Bengal Panchayat Elections Act. 93(1)C, it is covered. Now, my lord, see, next pair is issue in the nature of manner of each of them to allow the petitioner to participate as contesting candidate. But when the Form 12 has been granted, given, and the nomination process has been commenced, election nomination has been filed, 15, and according to them, it has been, rejection order has been challenged by them here. This is a
completely an election dispute matter.
So where is the rejection order over
But
here? There is
he
no
is-
rejection.
with them.
My certificate I have there.
No, no, certificate you have been declared uncontested, but there is no rejection order.
Yes,
That I
yes.
can-
Milord, that's on 17th, yes, Milord, same 17 June 2023. Milord, I will give like that matter.
No, here they could not file their nominations
No,
also.
my lord, my case is that
They have filed
after 3 p.m.
after 3
Oh,
p.m.
after 3 p.m.
That's same.
Kindly
Milord,
take
I will,
paragraph
the rejection order is there, Milord. I
In
can,
respect of each and every candidate, there are many petitioners.
yes, everyone, Milord, the rejection has been done in every cases.
My lord, kindly take
Milord,
paragraph
I have
19.
only one copy,
82 petitioners.
Milord, they are saying in their prayer itself,
Huh.
cancel the rejection order.
All right.
Therefore, rejection order is there.
There. Hmm,
Therefore,
hmm,
therefore, the rejection order is there on scrutiny. This is their prayer, Milord.
Rejection.
Milord, kindly see, issue a written nature of mandamus courtesy, commanding the authority each of them to cancel and set aside and or coerce and or rescind the decisions of rejection of nomination of the petitioners by the concerned respondents. Therefore, after scrutiny, the persons who are there only same equal positions. Then the Milord section 64, under section 64, subsection B, the Milord form 12 has been given to the uncontested candidates. That's Mr. Basu's clients. Their rights have been accrued. Now, Milord, whether it is an election dispute, Milord, and I am covered by Milord, all of my arguments which I have made it.
There was only one addition, subject to Mr. Banerjee has completed. 2018, Milord, judgment would have no application because here the petitioners got the High Court's order and security to file the nomination. Even then, they were not allowed, Milord, to allegedly file the nomination within time. Our point is we have filed the nomination within time. The officer got it recorded because of their own heroism. Here, Milord, the qualitative difference is the High Court granted us security that you go and file nomination. But even then, Milord, they did not allow us to file within 3. Therefore, this will not, Milord, in any way come
Where
within
is that order?
No, no.
Where is the order of the High Court permitting you to file the
High
nomination?
Court order to the
Yes, Milord, they went there. They went at 8 p.m.
Then who is responsible then?
Yes, you are responsible. You are responsible.
Milord,
They went there at
Police-
8
page
p.m.
3, my lord, page 3.
They,
3, my lord.
yes.
Page 3, my lord. And our case is that on the 20, on the day of 20, my lord, not the last day of scrutiny was 17. On 20, my lord, our name is appeared in the website, my lord. In paragraph 19, are specifically stated, my lord. That's our case, my lord, altogether. So, you know,
No, it appearing in the scrutiny, but this is what is being submitted, that as the nomination was filed beyond the prescribed time, that is the reason it has
why-
been cancelled.
That's the ground which will not made out by the authorities to reject these applications.
Yes.
The reason that the petitioners are illegally, arbitrarily, whimsically rejected. Milord,
It is submitted after.
Milord, if your lordships read paragraph 2 of the petition, they have said itself, the nomination of the petitioners, paragraph 2, last line, page 21.
Yes.
The nomination of the petitioners are illegally, arbitrarily, and whimsically rejected, showing the reason that the petitioners have filed their nomination after 3 p.m. of 15 June 2023. It is their case. And rejection is on the ground that they have filed it after 8 p.m. Therefore, if it is an illegally rejection, then it's an election dispute. Whatever the reason may be good, bad. And all that other arguments which I have.
Ultimately, you filed the nomination on
Yes.
the 15th.
15, my lord. Ultimately, filed on 15, my lord. Thereafter, our names appeared in the website up to 20, my lord.
Oh, at what time did you file?
My lord, I entered in the video premises before 3. My lord, thereafter, my lord,
Thereafter, my lord, what happened, my lord? They keep the nomination. But the video, because there is a huge queue, my lord. But kindly take notice of that, my lord. There is 82 candidates, more than 82 candidates, my lord. Each candidate, with each candidate, there is one proposer and 2 witnesses, my lord. So there is a huge queue, my lord. So it ought to be, my lord. In election day, what happened, my lord? If the election period up to 5, my lord, whosoever entered in the premises, then they might be took up to night 12, my lord. But whoever entered in the premises within 5, my lord, they ought to give opportunity. That's my altogether, that's my case. And not only that, my lord, my case is that, my lord, the last date of scrutiny was 17. On 20, my lord, our names appeared in the website, my lord. All of the sudden, my lord, our name vanished, my lord. That's my case. Or election dispute, my lord. This is an arbitrary act of the administration, my lord. This is not an election dispute at all.
Just a minute, just a minute. My lord, kindly come to its page 83 of the petition. Page 83 of the petition itself. See, 9 p.m. Admittedly,
This is not our handwriting.
there is anyway.
This is whose handwriting, my lord?
My lord, I can't argue in this way. Mr. He will do it in.
1 minute. Assuming that it was filed at 9 p.m.
Right.
Assuming. But the candidate, if he is there.
No, where
within
is
three-
the averment? Where is the averment? My lord, I have made already submission to your lordships. Before Justice Mantha, this was the case. And I have already submitted. These persons entered into the premises at 8:01 p.m. and they have ransacked. They have 2,500 persons entered. Video was shown to Justice Mantha, my lord, Mr. Justice Mantha. Therefore, this is a case where they have entered after 8 p.m. They were not, my lord, where this case is this, where this says that they were in the queue. Where is the case? Averments have been made. Now, my lord.
Paragraph 18, my lord. Specific averment.
Now, my lord, kindly see the complaint of the block development officer. My lord, kindly take, and I am just handing it over. Kindly see
Give me a
the
copy.
block development officer. I will give it to you. Please, just wait. I don't have much copy. Kindly see. To the officer in charge, Kashipur Police Station, Baripur District Police. Complaint against the incident occurred on 15 June after scheduled time of nomination. This is to inform you that on 15 June 2020 at 3 p.m. the nomination process so-and-so was over and the nomination venue was cleared. At about 4:48 p.m. a violent mob of about 2,005 persons carrying arms, rods, sticks and stones forcibly entered into office premises, breaking 2 lock gates. After that, they have broken into the office forcibly and vandalized the office. They have forced the ARPOs and other office staff to receive their nomination paper by obstructing officer on duty for performing their duty. This is the official complaint has been made before the officer in charge. And kindly see 17 June 2003 to the district magistrate and district panchayat election officer seeking clarification. I am to inform that on 50 at 3 p.m. nomination process and panchayat nomination when was cleared. Same, my lord. They have forced so-and-so a complaint about the matter has been lost to the officer in charge. I have informed. Therefore, if today, before your lordships, the averments is there. Today, before your lordships, the official documents are there. Who is correct or who is not correct? Lord, that cannot be gone into by the writ petition. That's similar the question of fact is there. And on the scrutiny, at the time of scrutiny, the Mr. Basu's clients raised objection. Raised objection. And we know the fact, and I have to act on the basis of the objection.
But I filed an application on the basis of that. And your lordship court was pleased to die in election dispute. Now, my lord, just wait, I will take 2 minutes time for mine. But before that, my lord, can I please this of the division bench? The entire case is theirs prevented. Can you straight away come to paragraph 33 of the division bench judgment? Kindly straight away come to paragraph 33.
Yes.
The issue as to whether there has been prevention or of obstruction to the intending candidates from making nominations at the present specific place is disputed question of fact which cannot be decided by of exchange of affidavits. Therefore, this court was not inclined to invite the parties to deal with such allegations by filing objections thereto. If there is any reasonable apprehension or prevention of obstruction of making nomination, or there has been any alleged obstruction, the aggrieved party has to take recourse to the provisions laid down in 2 subsection 2 of section 43. We have done that. We said that you are accepting their nomination beyond 3 p.m. because statute says, Form 1 says last time is 3 under the statute. And these are my objections we have filed. And on that matter, order has been passed. So this is the order we have challenged before your Lordship's court. My lord, now kindly see, this is the only order passed by my lord. In identical situation, my lord passed this order. There is no other material before my lord today. And this is the argument of Mr. Bhattacharya, my learned senior friend, that yes, this is a case which required election dispute to be raised. Very well. Number kindly see your lordship judge. There your lordship was pleased to delegate the matter to the election as an election dispute. There is no other material now placed before my lord in addition to the prayer which was filed in that application. So in my humble submission, your lordship could pass an order in conformity with the order passed by your lordships earlier. And now, my lord, my election has been declared. A certificate issue. If today, my lord, your lordship is going to entertain this application, meaning thereby my certificate of winning of election will be scrapped. These are the, my lord, I have placed before my lord on the last day.
You have not won the election. You have got the uncontested, prevented us from going there and now taking benefit of that.
He knows more than me in this field. Declaration granted under Act statute. So I have been declared elected.
My lord, who are the petitioner, who are declared the winning candidate, not against the petitioner, my lord. Kindly give the certificate. As per my own instruction.
Not in respect of the said
seat. I am representing 80 candidates. 82.
No, but then 80 candidates, are they against the petitioners?
I could not produce all certificates. I have handed over to you.
Yesterday, 12. No, now they are yesterday, 12 candidates. They handed over 12.
No, my lord. From my end, that all
this 12 was provided yesterday.
Kindly see. Form 12 has been issued in case of others.
Now it is a document. It is the custodial parties.
Investigated subject to, and my lord, kindly noted one thing, my lord. When this certificate issued?
26th. 26th. Karimul Islam Mullah. Item number 6.
This is Hodge. Hodge candidate appear and will find the nomination.
You have a report. Please give. Yes, please.
From the Bureau of Immigration. He had left India on the 4th of June, my lord.
4th of June, prior to the notification being published.
Yes.
Due to retire, come back on
He's supposed to come on 18th of July.
16th July.
16th of July.
After the day.
15th of July. So the entire process. Yes, Commission, what will be your submission? Yeah, sure.
Madam, this is the copy of the declaration that he is supposed to give. Last page. Last occasion, you should sort for this. This is available in the website as well as.
Yes, please. Yes. Moharuddin Ghazi
And Ahsan Ghazi filed their
nomination.
Yes, nomination at the office of the returning officer Meena Khan for Kumar Joel /12 15 seat.
No, but then if the candidate was not there.
No, Your Lordship, it is assumption, I will say. Is it not possible that a candidate signs the document, hands it over to its proposer and goes out of time? No, this is.
And is the candidate not required to remain personally present in front of the state officers? Say in the last occasion, Mr. Bandyopadhyay said that the candidate is required to remain personally present. What will you say? This is what the law says. Presence is required.
These I have uploaded.
The election, the notification was published on the June, 9th of June. He went on 4th and it is to be accepted that he signed the papers prior to that. It cannot be accepted at all. This submission cannot be accepted. Absolutely no.
Section 46, subsection 1.
Tell me one thing, candidate is not here. No, notification published by the commission on the 9th of June. He left on the 4th. So he's cancelled. Please come. No, when there is.
We have sought for investigation. We have sought for investigation.
What the investigation authority will do? The candidate is not there.
Who was the
No,
person?
my lord, the investigation is necessary, my lord, that this is who, my lord, filed this nomination, who secured this signature, everything is forged. Now, this is a serious thing with regard to, my lord, the election.
And please come.
Which is the basic structure of our constitution.
Instruction has been forwarded by the Intelligence Bureau, Ministry of Home Affairs, Government of India, mentioning that the petitioner Moharuddin Ghazi left the country on 4th June 2023 as Hajj pilgrim, and he is as Hajj pilgrim. Stop. Next. It appears that the notification was published by the State Election Commission for declaring the dates of the Panchayat elections on 9th June 2023. Stop. The Panchayat returning officer accepted the nomination on behalf of the petitioner. Now, nomination from the concerned candidate, that is Moharuddin Ghazi, and scrutinized the same and found the same to be in order. Stop. The name of the private respondent was put up in the final list of eligible candidates to contest the election. Stop. Next. According to the provisions of law, the candidate concerned is required to remain present. Now, is required to sign the nomination paper. Stop. And the declaration is required to be furnished by the candidate along with the nomination paper before the Panchayat returning officer. Stop. Next. Submission has been made on behalf of the State Election Commission that it may be possible that the candidate had signed the paper prior to leaving the country. Stop. The said submission cannot be accepted by the court. More so because of the reason that the notification declaring the dates of the election was published after the candidate concerned left the country. Stop. Next. The private respondent could not have anticipated that the notice of election, notification declaring the dates of election will be published, and he will and he signs the declaration prior to the date of publication of the notification. Stop. Next paragraph. The petitioners have prayed for conducting an investigation as to how the nomination papers of the private respondent could have been accepted. Stop. Next. The
Prayer B.
prayer B.
B.
Acha, permitting a candidate to contest the election when he is outside the country, relying upon documents which not relying upon, calls for an investigation by an independent
Your Lordship,
agency.
may I interject at this moment? Let there be inquiry by the State Election Commission.
Why?
Yes, kindly, Your Lordship, we will. come
Why?
up with a
For
very-
what reason?
Yes.
The appeal bench is there. You can
Kindly, Your Lordship,
obtain
kindly allows,
orders.
I will file a report to that extent. Kindly allows that.
Very well. I'll accept your contention. Next, from an independent agency. ठीक है जी? The learned advocate representing the State Election Commission submits that the matter will be inquired by the State Election Commission. Stop. Next. Let the State Election Commission inquire the matter and file a report before this court on 28th of June 2023, when the matter will appear in the list marked for orders.
I'm briefed, Your Lordship.
The communication made by the Additional Deputy Secretary dated 23rd of June 2023 be written with the records. One more matter is left.
Yes. Item
Sirajuddin Diwan.
Item 7, my lord, I am
One of the union, my lord.
nothing. You are giving-
Purpose is served.
Now expungement, maybe.
Why?
Why did you remain?
Because in case the court does not accept the report of the commission, then maybe the union authorities may be required. I do not know. It will all depend upon what is the report that is coming from the commission. One more matter is left. 7.
8,
Yes.
so. My lord, I am appearing, 7 or 8, it is?
My lord, I just
7,
remind
yes.
your lordships.
My lord, I am appearing for the state.
My lord, on the last occasion, your
Not
lordships,
more than 3 minutes.
I will not. My lord, on the last occasion, after hearing us at length, your lordships directed the commission to take instructions, that at least. Now, I just remind your lordship, this is scanning one block. 274 seats goes, my lord, uncontested. My lord, we went on 14th to, my lord, submission, file our nominations. We are prevented long before. We went 15th, tried to go on 15th. We are physically prevented. Paragraph 6A onwards. Now we lodged a complaint to the commission, your lordships will find at page 73 onwards, 15th June itself.
Yes.
My lord, at 1
And
PM.
Ms. Sinha was supposed to take
Supposed to,
instructions.
even then. And your lordships, your lordships pointed out to me.
Why?
My lord, can I make this submission?
Yes.
My lord, this is the case, my
Lord,
lord.
one thing, my lord, the state elected commission cannot submit.
I
My
have
lord,
followed it.
that's-
I have
that's
followed it. Yes.
Can I make this?
Yes.
My lord, in this, this scanning, there are 3 seats of the Jila Parishad. Kindly take note, my lord. In the 3 seats, All India Trinamool Congress filed their nominations. SUCI filed their nominations. They are saying no nominations have been filed.
No, their case is they could not file the
No,
nomination.
I am coming, my lord. Oh, I'm just coming. INC filed the nomination. If one doesn't go there, that's not the point that they could not file the. He has not gone there, other persons have gone there. Nominations papers have been filed. Then, my lord, 6 candidates have withdrawn. So far the Gram Panchayat seat is concerned, independent persons have also filed their nominations. Other political parties have also filed their nomination. Withdrawal is there. Therefore, nominations have been filed. What is his case? His case is kindly similar, that because of the disturbance, etc., criminal case, etc., they could not able to file their nominations. But if the nominations have not been filed, in that case, it is also an election dispute. It remains an uncontested.
So the same submission you made.
Same submission is there. Same submission. I am not required to take my submission. My lord, one of the, I just tell you, lordship, my lord, what has happened, this has not been stated to canning it too. Yes, my lord, your lordships will find a criminal case, suo motu criminal case, yes, a suo motu criminal case has been.
I think the same submission will.
No, it is a different factual. Suo motu criminal case has been initiated. Suo motu criminal case on that day.
Against whom?
Against, my lord, so many 56%, 27 persons have been arrested.
Yes.
Yeah. Now, one of the complaint has been made by one Sirajul. This Sirajul, na? It's Sirajul. No? So this baby Sirajuddin, Sirajul Islam Gharami, this and filed a writ petition before Justice. This matter was taken up by my lord, Mr. Justice Mantha regarding the police inaction, etc. Justice Mantha, my lord, Justice Mantha, just may I read it, my lord. Page 87.
No, I hardly have time.
Or, my lord, your lordships will find the order of Justice Mantha at page 87.
Yes. Yes, it was placed on the last occasion.
Listen. Now, my lord, in this matter also, already what has happened under section 64B, the uncontested candidates are concerned, my lord. The 64B of the Panchayat Act, under Form 12, the candidates have been declared as winning candidates. Have been declared as winning candidates. 64. They have been declared, yes, they have been declared winning candidates. Now, the declared as a winning candidates. Now, therefore, the prayer which has been made by the writ petitioners, kindly come to writ petition, signed similar. First, mandamus commanding the source to allow the petitioners to submit their nominations. This is time has gone, not possible, already can declare. But any of the prayer is not maintainable in view of the elections.
What? For orders on Monday.
Chalo.